that they have indicated that they are interested. Okay, looks like Anna has us on YouTube.
Yes, ma'am.
So, okay, I understand. And again, sir, I thank you for accommodating us and like I say, subject to other questions. I believe that we should be able to wrap up our hearing today, but I'll announce all that when we do the procedural parts of our hearing this morning.
Okey doke.
Okay, just let
Yes,
me know if you need anything.
I will.
Okay, Miss Anna, do you have your ears on? Don't know. Okay, I will call you then, Anna.
Hi, Dave.
Hi,
Oh.
Anna. How are you?
There you are.
Good, thank you. So yes, everything is set up
Yes, thank you. I see we're on the YouTube.
and you are the host now.
I am the host now. Okay.
I'll mute myself and let me give you a call. I need to ask you something.
Okay, let me mute myself then.
Okay. Good morning. This is recording, but the video. So Robert Lundin is asking me for the link.
Anna,
For
you're
the
not
link.
on mute. Anna, you're not on mute.
Mhm.
Anna. Anna, you're not on mute.
Good morning.
Good morning, Ms. Hurst. Good morning,
Good
Mr.
morning, Mr.
Bacco and Major Buchanan. David, how are you?
We are well, I think.
Yeah,
Looks like we're going to have a few more people.
Who is the speaker in the SPS office, please?
Good morning, it's Will Dubois.
Thank you, Mr. Du Bois.
Hello there, everyone. There he is.
Morning, Your Honor.
Good morning.
Good morning.
Good
H.E.
morning,
Burt.
Mr. Chairman.
Good to see you this morning.
Good to see you. Okay, I believe we have everyone that we need. So, good morning, and before we go on the record, let me just ask whether or not we are going to have any procedural matters that parties need to deal with.
Good morning, Your Honor.
Good morning.
Will Du Bois for SPS. While, as I think we'd indicated, SPS is not going to be objecting, if it's okay, we will have a comment on a procedural matter with respect to the administrative notice.
Okay, and we actually will deal with that particular issue. Mr. Du Bois try to hone in on exactly what it is that the commission is interested in. Okay.
Madam Hearing Examiner. Oh, sorry, Joan, go ahead.
Oh, I was probably going to ask the same thing Thor was going to ask. I wasn't sure if you wanted each of the parties that responded to the commission's order and bench request with testimony to label those as their own exhibits and circulate those to you and the parties, or whether you were planning to admit those as commission exhibits. It's easy for us to label them and circulate them if you would like us to do so. If not, I understand you may want to bring them in as commission exhibits. I wasn't sure how you wanted to deal with that.
And I actually hadn't thought about them coming in as commission exhibits, but that they were going to come in as party exhibits. But I can, I can think about that. I know. Well, let me ask, Mr. Nelson, is that the same question you had?
That is one of the two questions I had.
Okay.
The other question I had was whether you might be able to give us an idea of an order of witnesses. I've got
Yes.
a request from my witness to get some idea of where he stands in the batting order, and I wasn't sure what yours or the commission's pleasure was in terms of witness sequencing. So if we could address that as a preliminary matter, that would be hugely helpful.
Yes, sir. I will be doing that. Okay. Any other procedural matters that parties want to talk about? Nope. Okay. Very well. There you are. Mr. Lee, are we ready to go on the record, sir?
Yes, ma'am.
Very well. Good morning. We are here today in case number 20-00238-UT. This is in the matter of Southwestern Public Service Company's application for revision of its retail rates under advice notice number 292, authorization and approval to abandon its Plant X Unit 3 generating station and other associated relief. We are here pursuant to the commission's order issued in this case, reopening this case to present information on some select subject matters, and the commission has authorized me to hold another hearing. Today is the date, time, and place, as was noticed on the commission's website and as provided in the procedural order that I issued on reopening in this case. Along with me today is our court reporter, Mr. Lee. If anyone needs anything to do with the transcript, please see Mr. Lee directly. And let me also note, Mr. Lee, on behalf of myself and the commission, we thank you for being available to provide your court reporting services for this hearing on short notice. And I know that you had to reschedule some things in order to accommodate this. So thank you again, sir. We appreciate you. Also along with me today is the chairman of the commission, Commissioner Fishman. Commissioner Fishman will be asking questions of some of the witnesses. And I looked back at the our order of witnesses in the case in chief. And so basically, we're going to follow that order. And for those of you who don't remember, we're going to start off with SPS. Then we're going to have OPL. The FEA LES witness, who's only available tomorrow, would be taken out of order. Then there is the large customer group, the Attorney General, COG, Walmart, and staff. So that is our order of presentation. I guess to answer the procedural question that was posed before we began our hearing about how the preference of the commission in how to label or number the exhibits. I guess I would like them to come in as party exhibits, numbered with a reopen exhibit. Mr. Lee, which is less confusing, do you believe, for the record? Shall we just start with letters, or shall we start with numbers again?
Numbers.
Okay. So for example, Mr. Grant's testimony for SPS would be SPS reopen exhibit 1 if he was going to go first. Okay. Does that answer that question, Ms. Drake?
Yes, ma'am, it does. Thank you. So for FEA-LES, you don't want us to continue numbering from the previous exhibits? You want us to start over at 1?
Yes,
Okay, great. Thank you.
thank
That's
you.
great. And I'm sorry, should we just email those to all of the parties instead of a Dropbox link? That seems to be easier.
I have, if you have no corrections, additions, or deletions to that testimony, I need you to so indicate. Because I have already provided every exhibit that was sent to me to the court reporter for his ease of reference. So if you have a different exhibit than what you filed, you're gonna, and the only one that I know that that does is Mr. Pollock's testimony that I received yesterday afternoon. So I think we'll be good to go if unless like I say, unless someone else has deletions or corrections. And on that same topic, is any party opposed to allowing the testimony of witnesses that the commission has no questions for that testimony to be stipulated in? Okay, so just so that everyone is clear, my understanding is that the commission does not have questions for all witnesses that filed testimony. My understanding from our pre-hearing conference was that the parties are not going to have questions for each other's witnesses. Therefore, it seems to be most efficient to me that if the parties are not going to have questions of a particular witness, and the commission is not going to have questions for a particular witness, I believe it would be most efficient for us to stipulate that, again, subject to there not being any corrections, additions, or deletions to the testimony, since I believe that each of the witnesses who have filed testimony in the reopened case have included their verifications, and they were previously sworn in the case in chief.
Madam Hearing Examiner, this is Thor Nelson. I have a question on that.
Mr. Nelson?
So I was having my assistant, as we went through this discussion, prepare a revised version of Mr. Higgins's testimony, but the only change was attaching the label that you had indicated this morning of calling it NMLCG reopened exhibit number 1. So I don't know if that counts as a change or if you want to have us submit exhibits with the labels. If not, then that doesn't make any difference. But I just wanted to flag that to see if Your Honor desired a version of the exhibits with the appropriate name.
Mr. Lee, do we need to do that, or is an oral identification of the exhibit acceptable?
Oral identification.
Very well. Not necessary, but thanks for bringing that up. And there are questions for Mr. Higgins.
Okay.
Okay. Okay, so I'm not hearing, unmute yourself if you're not going to agree to this stipulation of testimony. Okay, last chance for the parties. Okay. All right. Very well. So we've answered that one. We've answered that one. We're going to deal with the administrative notice here in a minute. Well, no, let's go ahead and deal with that now. Part of the commission's order reopening this case indicated that the commission has interest in taking administrative notice of some information contained in 2 cases. And
Hearing Examiner Hurst? May I
Chairman Fishman,
quickly interject is that the request for administrative notice came through as a suggestion from general counsel. And I have to own up to the fact I didn't thoroughly understand what administrative notice means. And all I wanted to do was be sure that I could ask questions referencing prior cases that had been decided. And as long as I can do that, I don't think administrative notice is necessarily required. And that if it is, we can, determine that later.
very well, Mr. Chairman. Thank you for that clarification. Therefore, I will consider that until and unless the commission requests administrative notice of a matter, I will consider ruling on it at that particular point. There's not going to be a blanket administrative notice of the 2 particular cases that were referenced in the commission order. Based upon the clarification of the chairman, he wanted to alert the parties that he might be asking questions relating to those 2 particular cases. Okay, Mr. Du Bois. Is that ruling clear on administrative notice at this point?
Thank you, Your Honor. Thank you, Chairman Fishman. I think that clarifies where we are on administrative notice of those materials. I will observe that SPS had, based on the order, anticipated that those materials were all coming in, and had indicated we were not going to object to that, regardless of whether we thought it was the most efficient way of doing things. But we have quoted material from that in our testimony. I don't think that's, as I'm trying to think through the procedure here, I don't think that's a problem to have quotes from that without that material coming in wholesale. I think those 2 things are not inconsistent with one another. And I will say too, given that the commission had identified concerns with the stipulation related to those materials, SPS does appreciate having the opportunity to respond and explain on those. We do believe that the stipulation is fully warranted, including with respect to those items. Per some of our earlier objections in the case, we do still have procedural concerns about places where there may be outside concerns or outside research that we may not be having the opportunity to respond to, but that doesn't seem that there's anything in particular to do with that right now. And so I'll net out to thinking that, as I've said, we are probably on okay procedural grounds to have no administrative notice of those materials, but have the quotations with citations to those materials. If we were going to differentiate between them, I would also note that the IRP materials are considerably less voluminous than the WIN-CCN. And I think those are probably more heavily what SPS is cited to if it comes to a question of how to proceed on that. But again, I don't think we necessarily need to go there right at the minute.
Very, very well, Mr. Du Bois. I would alert you to having your loads and resources table available for questions, potential questions. All right, sir? Okay, do I need to hear from anyone else?
Ms. Hurst,
Yeah, Mr. Marks.
if I could, yes. Given the current status of the administrative notice, Sierra Club, I think, is in agreement with Your Honor and with SPS, but I did want to preserve for the record that, well, Sierra Club takes no position about the WIN stipulation cases, but as to the IRP case, which is 21-00169 UT, we just want to point out that that was not a fully litigated case. Sierra Club disputed SPS's IRP. Sierra Club, SPS had an opportunity to respond to Sierra Club's objections, and staff weighed in, but Sierra Club did not have any opportunity to reply to those things. We did not have the opportunity to examine SPS or staff in a hearing. And so Sierra Club does not object to SPS or any party quoting from the IRP case materials. We don't have any objection to the commission referencing it and saying this is what SPS put in its IRP. We would have an objection if it reached the point that the commission was going to find that the resource acquisitions in the IRP are the resources that SPS should or should not acquire. It's a planning document, and the commission decided several years ago that it didn't want to litigate these cases, and Sierra Club did not further litigate it, even though we disputed the end result. And so to summarize, we don't object to, I think, is, referencing the case, referencing it as what SPS put forward as its proposed resource plan. We would object if the commission elevated that to a finding about whether resources should be acquired or not acquired, when that was never litigated in the case.
Thank you, Mr. Marks. The commission obviously will consider whatever evidence, like it does the evidence in the rest of the case, as to what's relevant or not. And in light of, or in making that determination, of course, one would always consider what type of notice and procedural posture that the information came into. And I apologize to the parties. I feel like we're just sort of continuing, from a few months ago. But if we can, I guess I should go ahead. I've announced our court reporter and Chairman Fishman, but I haven't gotten the parties' appearances on the record. So perhaps we ought to do that. And I'll begin with you, Mr. Du Bois.
Thank you, Your Honor. Will Du Bois for Southwestern Public Service Company.
Good morning. Ms. Coleman?
Thank you, Your Honor. Katie Coleman for Occidental Permian Limited, and also appearing will be Philip Oldham and Michael McMillan.
Very well. Good morning. Major Buchanan?
Good morning, Your Honor. Major Holly Buchanan on behalf of federal executive agencies.
And Ms. Drake?
Joan Drake on behalf of Louisiana Energy Services, also called LES.
Good morning. Mr. Nelson?
Thank you. Thor Nelson on behalf of the New Mexico Large Customer Group from the law firm of Holland and Hart.
Good morning. Mr. Elliott?
Good morning. Gideon Elliott on behalf of the Attorney General's office.
Hello. Mr. Moffett?
Good morning, Madam Hearing Examiner Mike Moffett on behalf of COG Operating.
Good morning. Mr. Bartell?
Good morning. This is Randy Bartell on behalf of Intervenor Walmart Incorporated.
Hello. Mr. Marks?
Thank you. Jason Marks appearing for the Sierra Club.
And Mr. Bagatko?
Good morning, Madam Hearing Examiner. John Bagacco on behalf of the New Mexico Public Regulation Utility Division staff, and I will be accompanied later in this proceeding by Georgette Ramey, our staff witness for this leg of this case. Thank you.
Good morning. I believe I have everyone and apologize if I don't. So unmute yourself if I've forgotten you. Let me also indicate for the record that I did receive requests from two parties to be excused from appearing here today, understanding that they waive, of course, any examination of the witness that they were not here for, and also they also waive participation in any procedural discussion, and I did grant those requests. And the first request was from Ms. Lynch for CCAE, and then the second request was from Ms. Beatles for WRA. Okay, very well. As I indicated, it's my understanding that the commission does not have questions for all witnesses. Therefore, I believe that it would be administratively appropriate for us to excuse those witnesses after their testimony has been stipulated in, and we will begin in the order, the examination order. Ms. Drake, Major Buchanan, Commission has no questions for your witness, Mr. Gorman.
Okay, thank you.
Does the testimony filed by Mr. Gorman on the reopening, which I would refer to as FEA LES Reopen Exhibit 1, are there any corrections, additions, or deletions to that testimony as it was filed on Friday, the 12th?
No, ma'am. And the version, the labeled version that we just circulated by email is identical to the version that was filed. No corrections, no changes.
Is there any objection to the introduction of FEA LES Reopen Exhibit 1, Mr. Gorman's direct testimony? Hearing no objection, FEA LES Reopen Exhibit 1, Mr. Gorman's testimony is admitted. Thank you, Ms. Drake, Major Buchanan. The second witness that I believe that the commission has no, and these are, I know Mr. Gorman is not available till tomorrow. These are subject to the information I have at this time. So let me just add in if the commission discovers, since we do have this notice for tomorrow afternoon, the commission discovers that that the witnesses that are excused, that there's questions, then I don't believe that's going to happen, but I'd like to prepare just in case. So then going next in the order, Mr. Bartel, your witness, Mr. Chris, who's actually, I believe, here on the line, or on the line being on the Zoom. Mr. Bartel, the Walmart Exhibit 1, reopen Exhibit 1, Mr. Chris's testimony. Is there any correction, addition, or deletion from that testimony as it was filed on Friday?
No, there are no corrections or changes, and yes, we would move that it be admitted by stipulation.
Very well. Any objection to what's been identified as Walmart Reopen Exhibit 1, Mr. Chris's testimony in response to the commission's order? Hearing none. Walmart Reopen Exhibit number 1 is admitted. Thank you, Mr. Bartel. Thank you, Mr. Chris. Mr. Bagatko.
Yes, Madam Hearing Examiner.
Are there any corrections, additions, or deletions to reopen exhibit number 1, Ms. Ramey's testimony in response to the commission order?
There are no additions, deletions, or corrections to be made to that document, Madam Hearing Examiner.
Very well. Any objection to what's been identified as staff exhibit reopen number 1, Ms. Ramey's testimony in response to the commission order? Hearing no objection, staff reopen exhibit number 1 is admitted.
Thank you.
Thank you, Mr. Bagatko. All right, very well. I think that at this point takes care of the matters that I wanted to make sure that we got completed. I believe we will now begin with SPS's witness. Is that going to be Mr. Hudson, Mr. DuBois?
Yes, Your Honor, I believe he's in the waiting room.
He is in the waiting room. And just to remind people, we are on YouTube, so anything we say is out there in internet land, and so there you are, Mr. Hudson. Good morning, sir. You are muted. There you go.
Yeah. Thank you. Yeah, right when you said that, my computer was telling me that too. Good morning, Madam Hearing Examiner. Can you hear me okay?
I can hear you.
Yes.
Mr. Lee, do we need to re-swear, or can I just remind?
You can just remind.
Thank you, sir. Mr. Hudson, you previously testified in case number 20-00238. Do you remember that?
Yes, I do.
Okay, and you gave that testimony under oath. And so I would just remind you that in this reopen proceeding, you are bound to that continuing oath, sir.
Yes, Madam Hearing Examiner, I fully understand.
Very well. Go ahead, Mr. DuBois.
Thank you, Your Honor. Good morning, Mr. Hudson. You have in front of you a document titled Testimony Pursuant to November 3, 2021 Order in support of June 23, 2021 Uncontested Comprehensive Stipulation of David T. Hudson on behalf of Southwestern Public Service Company, dated November 12, 2021.
Yes, I do.
And was that prepared by you and under your direction and supervision?
Yes, it was.
Do you have any corrections or changes to that?
No, I do not.
If you were asked the same questions now, would your answers be the same?
Yes, they would.
Your Honor, I would move, I think would be SPS reopen 1 into the record.
And Mr. Hudson, do you have exhibits that are attached to your testimony?
I have one exhibit and then I have some work papers.
Okay.
Attached, I have, it's really called attachment DTH1, and it's 2 pages. And then I have 8 pages of work papers.
And attachment DTH1 is entitled Illustrative Updated Exhibit A to the stipulation using actual 2021 fuel costs. Is that correct?
Yes. That's the page 1. Page 2 is just a duplication of exhibit A to the actual stipulation.
And so does the second page, which was the exhibit A to the stipulation, is that the document that we kept referring to and had up on the screen during the hearing in chief?
I believe so. I don't recall, during my testimony that we had it up.
Okay.
And I did not watch the whole hearing.
You didn't?
Honestly, no, I did not.
And I'm kidding you.
I
watched the whole hearing.
I appreciate you too.
So I'm just trying to understand the difference between page 1 and page 2. Do you know the difference?
Yes, I do. I prepared page 1. I mean, basically what I've done is I've updated for the avoided fuel costs that we're seeing in the year 2021. They've gone up significantly since we filed the case in January of 2021. And so basically I've gone from a $39 million of fuel and PT savings in New Mexico up to 50.
I'm sorry. I've gone from, and you broke up just a bit.
Okay, I've gone from 39.9 million of fuel and PTC, which is production tax credit, savings in New Mexico jurisdiction, up to $56.4 million of fuel and production tax credit savings to New Mexico.
Okay.
That's the difference.
Okay. Thank you, sir. And then you said you have work papers. How many pages of work papers? We have 8.
There are 8 pages, including the cover page.
Okay, very well.
Madam Hearing Examiner?
Yes, Mr. Nelson.
Sorry, Mr. Lee, Thor Nelson. I just wanted to clarify with yourself or Mr. Du Bois if the work papers are being incorporated as part of SPS reopened Exhibit 1, just to get our record straight.
For SPS, part of that had been the intention, yes.
Okay.
Okay.
Thank you.
Very well. Any objection to what's been identified? Oh, and okay, so you answered them the same, and you prepared the exhibit. The answers are true and correct to the best of your knowledge?
Yes, Your Honor, I answered that. Yes, they are.
All right. Any objection to what's been identified as SPS reopen exhibit number 1, Mr. Hudson's testimony in response to the commission order? Hearing no objection, SPS reopen exhibit 1, Mr. Hudson's testimony is admitted. Chairman Fishman, you have questions for Mr. Hudson.
Yes, and Mr. Hudson, good to see you. And thank you for your thorough response to our bench request, or whatever that whatever it was.
Yes,
Technically.
Mr. Chairman, you're welcome. And I just felt like, given that it's 4.5 months after we filed the stipulation, that it was really important that I be the one that start off addressing any concerns that you or the commission may have.
For other witnesses, I'm going to have more questions for Mr. Hudson than for most of you. So please don't panic if this one feels like it's going a little long. But I think we can get through this stuff pretty quickly. Madam Hearing Examiner, I should warn you, I'd like to get that first page of the exhibit we just spoke about up on the screen a little bit as we go. That'll be coming shortly. If
Okay.
you can do that.
I will attempt to do that, Mr. Chairman.
And okay. So just some odds and ends questions. On page 11, we talked about, there was a reference to, of your testimony, there was a reference to the Harrington conversion from coal to gas being part of this case. And I was a little confused. So straighten me out. I haven't had a chance to take a look at the record. Has that already been approved? Or is that, I thought that was underway, or am I confusing cases?
Well, yeah, you're confused. It's, of course, everything in rate making is very complex, but in this case, we had requested to accelerate the book depreciation of the coal assets at Harrington Station. And that's what the parties have stipulated to, and it was in our filing.
Okay.
We also have a CCN pending. It was not perfectly clear to us whether one was necessary or not, but out of an abundance of caution, we filed to amend our CCN to reflect that we are converting the fuel that we will be burning in the same boiler.
I'm
using the
sorry. I'm sorry. To amend our CCN.
To reflect that we will be using a different fuel in the same boiler and using the same steam turbine and same generator at the power plant. We're just converting it from one fuel source to another.
Okay. Thank you. That clarifies it for me. Appreciate it. On page 10, and this is kind of a nit, but you're testifying that Sagamore was 42% of the proposed stipulation revenue increase. That's in your original proposal, correct?
Yes, that was in our direct case.
Okay, so I did a little back of the envelope, and in the stipulation, it's closer, it's around 60%. Would that be correct?
I don't know. I don't know what kind of envelope you used.
I just took, instead of 87 million as the revenue adjustment, 62 million as the increased revenue requirement, and made that the denominator.
No, that would be not a proper calculation.
Oh,
I mean,
okay.
clearly, the parties reflected that they did not agree with our cost, our return on equity. So if you go look at the revenue requirements for Sagamore, you can see that they came down in the stipulation.
Oh, okay.
So it's stated in the stipulation.
Okay. And what did it come down to?
Well, for purposes of calculating the revenue requirements and the economic 10-year test, not necessarily exactly what's reflected in the settlement revenue requirement. I need to look here and find it. The annual revenue requirement for Sagamore is $38 million.
Okay, so it's actually, go ahead.
38,057,206.
Okay. So it's actually a little higher than the 37 million that I did on the back of the envelope.
That's
Okay.
right.
All right, so it's might be a little higher than 60% of the total settlement based on that information, correct?
It could be if you're assuming that's the exact number that we
Yeah.
that was used in the settlement.
It's not a huge deal, just want to get that clear on the record. And I'm gonna, you make a lot of comments about regulatory lag in your testimony. And I understood your testimony to say that regulatory lag is the primary component in the low ROEs, low actual ROEs that SPS is projecting. Am I understanding that correctly?
Not only projecting, but we're actually realizing. Right now we are billing a rate that was based on a test year ending March of 2019 with a reach forward to August of 2019. So we've put in a tremendous amount of capital to serve our New Mexico customers, and we're neither earning a return of that or on that. We've also had increased O&Ms through normal inflation. So we're not recovering any of that, other than we are recovering some increased revenues. That's helping to cover part of it, but it's not covering all of it. So the net effect is it's diluting our net income for our New Mexico jurisdiction.
And how much, what's the asset balance that hasn't been incorporated into rate base yet that's creating this? Do you have a rough number for that?
I do not have it in my mind, but I mean, you can just go look at it, what's in this case compared to what was in the last case.
Okay, so it's primarily covered in this case or not?
I'm sorry, I don't understand your question. It's primarily covered.
So are there assets that you've acquired that are not considered to be included in the rate base in this case that are still outstanding for a future case?
Sure, absolutely.
Okay.
The reason is our test year for this case ended September of 2020 with a reach forward of February of 2021.
Okay.
We continue to make increased investment in New Mexico to help, one of the hottest areas as far as economic activity in New Mexico, much less in all of our service areas. Just last week, we put in service another $100 million of assets that are highway funded under the Southwest Power Pool and allocated across the whole pool.
Sorry,
But again,
I'm sorry, 100 million in assets and what?
within the Southwest Power Pool that are not even yet proposed to be recovered in rates. Those assets, of course, are allocated across the whole Southwest Power Pool because they are highway transmission assets under the SPP Open Access Tariff. There are other investments that we continue to make to serve customer requests in New Mexico, also to maintain reliability and replace older assets that are in need of replacement as we meet our obligation to serve in New Mexico.
Okay. You have a table and you make some comments at the top of page 19 of your testimony about the fact that fuel costs have gone up significantly, as I think we're all aware. And you created your exhibit or appendix. And thank you H.E. Hurst, you've got it up there. Appreciate it.
You're welcome, sir.
And you pointed out that the savings to customers and the economic benefits of Sagamore become greater as fuel costs go up. Am I understanding your basic point there correctly?
Yes, we are avoiding, they're avoided fuel costs. So we are avoiding those costs to the benefit of our customers. That was one of the primary reasons why we proposed to build Sagamore and Hale, besides their renewable attributes.
Mm-hmm. And as part of that discussion, you pointed out, and we're looking, I'll just look at total residential percent increase on total revenues on the exhibit, and they've got the number 8.42%.
Yes, I see that.
Okay. And you point out that the as the fuel costs go up, it actually it impacts the calculation of the total percent increase on revenues. In effect, it impacts that percentage calculation, and that in fact, as it goes up and the benefits increase, the actual rate or the actual revenue increase calculation goes down for that particular class. Am I interpreting that correctly?
That's right. The fuel savings, and what we're doing is we are measuring the impact of the increased base rates as a result of the wind asset compared to the fuel savings for the wind asset.
Okay. So that's great for everybody, but I don't think it's a secret that in the stipulation, I'm very much concerned about the disparity in the impact on the total bill of various customers. And that, while it's true that benefits total residential and their total, the percent that their total bill goes up actually becomes less, the impact is even greater for large and primary customers. And in fact, the disparity between the changes in the total bill becomes even greater. Is that correct?
Well, I don't think you're looking at it in total. If you just look at it for the wind assets, I mean, with the wind assets only make up one component of this overall case. I think as I testify in my supplemental testimony, you know, one of the biggest issues is the continued subsidization of the residential class. If you look at what we originally proposed, we proposed almost a 50% reduction of the subsidization to residentials, and that's what the parties were taking issue with. I'm not quite following what you're talking about.
Yeah, that's
total revenue.
That's not the question I intended to ask. So I'll try and be more clear. So I'm going to go down to, again, percent increase on total revenues, and go down to large general service transmission. And what had previously been a 1.48% reduction in the stipulation, that you can now see. Thank you, Hearing Examiner Hurst. She's way ahead of me. Now that becomes 6.6% reduction. Stay at this screen for a second at the original stipulation. And so I've got in the original stipulation, 10.84% increase for residential versus a 1.48% decrease for large, just as an example, for large service transmission. And the total bill, the disparity in the rate adjustment, if I add those two numbers together, is roughly 12.5%. So I'm just adding 10.84 to 1.48. And excuse me for not having a calculator. But that's the roughly the differential between the rate impacts is 12.5%. Would you agree that that's the case?
I would agree that 10.84 plus 1.48 is just above 12. If that's what you were asking.
Yeah, correct.
But I don't know that I agree with any conclusion that you'd be reaching from that.
Okay, now let's go up to the revised numbers that you developed.
And Chairman Fishman, if I could just interrupt for a moment.
Sure.
Mr. Lee, would you please indicate that Commissioner Hall has joined the Zoom reopen hearing? Thank you. Go ahead, Mr. Chairman.
Welcome, Commissioner Hall first. And now I want to scroll up to the revised numbers with the higher fuel costs. So now I'm looking at, again, at the total residential, 8.42%, and the total commercial and industrial, which is minus 6.66%. 6 and 8 is 14, 4 and so it's about approximately, if I add those two numbers together, the disparity in the total bill amount change is now 15%. So that, would you agree that that's the right way to add up those numbers?
You just add up the two numbers.
8.42 plus 6.66.
Yes, sir. I was trying to explain that.
Yeah.
8.42 plus 6.66. Yes, that gets you 15. But there's very logical explanations for that.
Oh, no, I don't, there's nothing wrong with it. It's just what happens. It's just the way the formulas work. So,
well, there's a rational basis for that. And I wouldn't say it's formulas, but the result.
How the math works.
Yes, Mr. Chairman.
Okay. So, I'm not asking you to draw any conclusions on that, but I will say that while it's good for ratepayers, it certainly doesn't mitigate the issue of disparity in rate changes that I'm concerned about. You may not be, but that I'm concerned about.
Well, I think the very basis for it is the LGST class that you've been referring to takes power at about a 90 to 95% load factor. They use a lot of energy throughout the day, all year long. Residential is a much lower load factor customers. So I would totally expect this result as you get more energy fuel savings, avoided fuel savings, you're going to get more energy savings for a higher load factor customer. That's just basics rate making 101.
Yep.
The other aspect of it is
I'm sorry. That's just basic
rate making 101.
Thank you. Sorry for interrupting.
If you look at residential, on their base rate side, they're also paying for distribution assets that the transmission class does not pay for, because the transmission class takes it straight off of the transmission grid. They have their own substation, their own distribution lines. So that factors into this overall calculation also. But no, I'm not startled at all by these calculations, but it does help residential customers as fuel costs are going up as far as avoiding them. Now, there's still, customers are paying increased fuel costs, but the wind, no question, the wind assets are providing greater value to residential customers. And that's what I was trying to point out.
Yeah, thank you. And I take your point. On that level, I certainly agree with what you're saying. And I do understand exactly what you're saying about load factors there. So thank you. Okay, I will, all the parties, since you're the first witness, you get to answer this first. All the parties just make a statement that courts favor stipulations to save litigation. And the argument being that costs are saved and there's more administrative efficiencies. Has any court opined on the merits of black box settlements? Do you know of any?
I am not an attorney, but in my practice in New Mexico, doing regulatory matters for over 37 years, we've had a lot of black box settlements over the years. And so I believe it's my understanding that the commission has encouraged and accepted settlements in the past. And I think this one's uncontested and results in a fair and balanced and reasonable resolution of this case.
So I take your answer to be no, that you're not aware of courts opining on the relative merits of a black box settlement.
That's correct.
Okay, thank you.
Chairman Fishman, Your Honor, given that these are legal questions, I'd ask that we be able to give a legal response to those in addition to what our fact witness happens to know or not know.
Yeah, absolutely, no problem.
Thank you.
Chairman Fishman, would you like me to consider the request and your agreement to the request to be part of a commission bench request that the parties respond, file a written response in the record regarding that issue?
Yeah, that's fine if that's if you feel that's the best way to go. I defer to you on procedural stuff because I'm a procedural idiot and I own up to it.
Well, do you want to make it mandatory or permissive?
Permissive.
Okay, very well. Consider it to be a commission bench request that parties may file a written response as to any legal implication from the courts as to black box, what's been referred to as a black box stipulation. Okay, go ahead. Thank you, Mr. Chairman.
an argument that I also see throughout the testimony from all the parties. Well, actually, some parties testified, and I believe you did as well. I don't have it right in front of me, but that we can, to the extent that issues are not resolved in the black box settlement, we can resolve them in a rate case coming up that you're planning to file in not too long. Was that part of your testimony, or am I pulling that from someone else? Forgive me.
That is my understanding, is this settlement does not establish any precedent, and therefore in the next case, the commission can investigate and determine whatever it deems reasonable and prudent based on a rational basis with justification.
Would you agree the downside of that is that we have to revisit these issues because we didn't resolve them now?
No, I don't see a downside. I think there's tremendous upside for the commission in that we are resolving these rate matters for today going until the next rate case. I think that's a benefit to everybody. And it's, like I said, it's an uncontested stipulation.
Frankly, that answer confuses me because clearly the parties were not able to fully agree, and we come up with this black box. And I, as a commissioner, don't see what's in it. And quite frankly, the public doesn't either. And what's to stop us from pushing it out again and do another black box next time we come around and you all can't agree?
Well, clearly, if we do not agree next time, it'll be a litigated outcome. If that's what you're asking me.
Well, this time there were things you couldn't agree on and you decided to black box them. Why wouldn't that just happen again next time if we say yes?
I'm not saying it could or could not happen, but clearly the settlement in this case is within the zone of reasonableness of the issues that were being presented in this case. So I think the settlement is just and reasonable.
Do you think there's any possibility that the parties could get together and make this a non-black box settlement that would set precedents for the future, so we don't have to go through more debates on these issues going forward?
I do not believe so. Every party had their own position on various issues, and we came up with this compromise of this settlement. Whether we litigate it now or next time, it's the same thing. I don't see why you would not accept the settlement at this time.
So your position is that it does not harm the commission's decision-making ability or the public's ability to understand how we got to a particular rate agreement to have a black box.
We've been doing it for 37 years, Mr. Chairman, and I don't believe the public barely understands the lengthy notices we send out, much less what we're talking about right here. It's up to the parties, the hearing examiner's recommendation, and the commission to make these decisions.
We do public hearings to make these decisions transparent to the public. Does black box stipulation serve that purpose?
Yes, they've all had the opportunity to participate.
But they don't have the opportunity to see how the house was built. Meaning that they don't see the assumptions and the particular decisions that were made to lead to a particular result, because it's hidden in your black box. And more importantly, the commission doesn't see that.
I disagree with you. They had full opportunity to participate and see and be involved in the discussions. So due process has been given. The commission has all the evidence that supports the stipulation along with the original testimony in the case. And they can clearly determine that the settlement is within the zone of reasonableness given the issues in the case. And I don't see why the commission would go out and suppose some other issues outside of what the parties are adjudicating in the case. But again, I'm not an attorney.
So in this case, we clearly had not resolved the issue of whether Sagamore Hill would be energy allocated or allocated under some other format. Doesn't that just create more uncertainty in the future when we have a future rate case and that issue's been unresolved? And now we either resolve it or we don't again?
I don't think it creates more uncertainty. No. Whenever we file the next rate case, I'm sure parties will have issues with everything we do. Some parties will like it, some will not. On various issues. There's hundreds of variables that go into a historic cost of service study.
Okay, thank you. I'm going to go to the bottom of page 34. And you're talking about the FPPCAC. And you refer to excess revenues from energy sales being credited to customers in the FPPCAC. I just wanted to get a clear definition of what is meant by excess revenues.
Okay. We are right now in the interim period. The base rates have not gone into effect. So what I'm talking about here is during the interim period under the CCN order, the commission approved that we would sell the energy of Sagamore, the New Mexico jurisdictional portion, into the Southwest Power Pool integrated market.
Mm-hmm.
And so the company would keep the revenues and the production tax credits for this interim period, but compare it to the revenue requirements. And if we are collecting more than the revenue requirements, we're going to flow those back to New Mexico customers. So basically, even during this interim period, if we're collecting more revenues and PTCs, which we have been under the current calculations, we would flow those back to New Mexico customers through the fuel factor. Now, once the commission approves the settlement, we will go back and recalculate it using the settlement revenue requirements for Sagamore. We will not collect more, but if we have more savings, we would give it back to the customers.
I'm sorry, can you make that statement again, that last statement?
If we have more savings, we would credit it back to the customers through the fuel costs.
So we discussed the number, it was, you said in the stipulation, 38 point something was the revenue requirement for Sagamore that's in the stipulation?
Yes, 38 million.
Okay. And so you're saying that if there's the Southwest Power Pool market pays more than 38 million, that's credited back to customers in the FPPCAC?
That if we get paid that for the market revenues plus the production tax credits as grossed up for the tax rate. You got to
I'm
consider
sorry,
both.
sir. I'm sorry, sir, your voice is not coming through clearly. Plus,
Okay.
plus the production task.
The production tax credits as grossed up for the income tax rate. So the savings to customers or to the company during this interim period are the integrated market revenues plus the grossed up PTCs.
Okay. Thank you. And I'm going to go back to the exhibit. Well, let me ask one other question. What happens in the case on that topic? What happens in the case where revenues from those sales are lower?
It hits our net income for that month.
Okay.
It's a hit to the company, not to the customer.
Okay, so it hits your, I'm just taking a second to let that, be sure I understand that. Okay, thank you.
We are talking about the interim period before the asset goes into base rates and base rates go into effect in this case. And that's why we're interested in getting base rates in effect, you know, now that we're close to 5 months after filing the stipulation.
I see some challenges calculating that, but I'm not going to get into that here. I think you guys will figure out a way to handle it. So going back to the exhibit, I did have one question that looks like a discrepancy, and maybe I'm misinterpreting. Go to total proposed revenues with new fuel. And actually, I'm just looking at the residential service line. And I see that it's 81,715,000. Do you see that?
Yes.
Okay. And now, Madam Hurst, could you please take it down to the original chart? And there I'm looking at the same line, residential service, total proposed revenues with new fuel. And the number is higher, 83,426. And I may be misinterpreting what this column's meant to show, but it seems to me, if I'm interpreting correctly, that the number should be higher when the fuel costs go up.
Okay, you are confused, Commissioner.
So help me out.
You have it directly backwards.
Okay.
It's avoided fuel costs. They're savings. So you'll see right there, we have 3.9 million of fuel savings on the second page. We have 5.5 on the first page. Okay, right there, you can stop. You can see the 3.9 million of fuel savings.
Oh, okay, so you're doing that. Okay, I see what you're saying.
Yeah, I'm saying there's more savings, therefore the total revenue is going down. Yeah, if you have more savings, the rates that customers are paying, including the fuel clause, are going down when you're looking at this case.
But would you agree that the total customer bill is going up?
No, not when you're just looking at the issues in this case.
No, let me rephrase that question. I'm sorry, I cut you off there, and I apologize. When fuel costs go up and I look at my bill and I look at my base revenues charge, and then I add on the FPP CAC, that the sum of those two numbers will be higher on my bill when fuel costs are higher.
Okay, so basically, what I'm doing here is I'm measuring the impact of the wind on customers, all right?
No,
And
I,
it's-
go ahead,
okay.
I'm sorry.
Yeah, so it's creating more savings as there's more avoided fuel costs with higher fuel. It's true that the FPP CAC is going up in this period, but that should be then reflected in the total revenues further to the left. And so when you reflect that for total revenues at the beginning, really what that's going to show is the actual percent total revenue increase on the far right is actually lower because the customer's bills in the first instance are higher, therefore your denominator is higher, and therefore the increase is the same, therefore the percent increase. So I'm looking at this in a conservative manner. Really, if you take into effect, and I think some of the parties point this out, I can't remember who, but fuel costs are going up. So actually a result of this case is even a smaller percent increase on the customer if you take into account.
I'm sorry, on the customer, if
you take into account the higher FPP CAC costs.
So I take your point. I understand it and agree. But my question is the total dollar amount on the customer's bill, even though they've saved more money as a result of Sagamore, the total bill, when I add FPPCAC and the other charges, will be higher in the case when fuel costs go up.
That's correct.
Okay, thank you.
Yes, the FPPCAC is going up. It's largely a function of doubling of natural gas prices.
Yep, and
so when
I'm sorry.
So when you reflect all of that, it would actually show that the percent increase as a result of this case is actually going down. It's below the 10.84. As I point out in my testimony, there are other savings coming out of the stipulation that are not reflected here. We have the LP&L credit, and then we also have.
Sorry, we have the LP&L.
Yeah, LP and L. It's an and sign, or Lubbock Power and Light is what it stands for. We have that credit that's not reflected in these numbers. And we also have a deferred fuel credit that we've been hanging on to. And again, it's been kicked from one case to the next. So there's an instance of pushing matters to future cases by the commission. So once we reflect all of those, the percent increase actually goes down even more.
Mm-hmm. Okay, thank you. So I'm going to go down, talk a little bit now about cost of service issues and how we divvy up the cost, how we calculate the cost of service and how it got so, there's such a discrepancy between the actual cost of service study and current rates among various classes. So historically, how did the cost of service get so divorced that our calculated cost of service get so divorced from the actual rates?
I wouldn't characterize it quite as strong as you have, but clearly we have been getting the message from the commission and commissioners that they like to mitigate residential rate increases because residential customers are the ones that vote for commissioners. So we have been given pressure to mitigate residential rate increases. And by doing so, we've been putting it for a number of cases into some of the other classes.
So this situation has been persisting for a fairly long time.
I would say it's for a number of years. I mean, there's just been this inclination to really mitigate residential rate increases by moving it to other classes. And you got to remember, Chairman, rate making is not an overly precise process. There's lots of give and takes. There's part of art to it. So people can get so wrapped up in, oh, you got to allocate costs to the 10th decimal place. I've seen a lot of people that have worked for me, and I say, hey, you guys you're getting lost in the snowstorm here.
Yeah.
That you can't do this. What we're trying to do is come up with a reasonable outcome.
Right.
That's in the public interest.
Right. And, I'll note that certainly in your original filing, you guys made an effort to mitigate the way you divvied up the increase. You made a strong effort to mitigate the impact on residential and small commercials. So
yeah, we did, and it was significant. It was about 50%.
Yeah,
the increase got mitigated. And to be honest with you, my personal feeling is no good deed goes unpunished.
On that one, I agree with you. We share similar life experiences. So this is my big picture question. And I'll break it into a few smaller questions in a second. I believe the facts show us that those two customer classes currently are under financial duress. And I understand cost of service parity, and I understand that limiting interclass subsidies is certainly one of the things we try to achieve in balance. But this has been going on for years, and these customers, it seems to me, are under more stress than ever. Why does it suddenly become an urgent issue in this case? It seems like the timing is really bad.
Can you explain to me which two classes you're talking about that are under financial distress?
Well, I would say residential.
I'm trying to make sure I understand your question.
Yeah, no, it's a good question. I would say residential and small general service. And, I'll go through a couple of things that lead me to believe that's the case and ask you to comment on whether I'm interpreting that correctly in just a moment. But if you accept the premise that those classes are experiencing financial difficulties, or at least significant numbers of customers within those rate classes, does it make sense to be trying to even out the cost of service and address those subsidies now in this rate case at this time?
I do think there is a limit, and the parties were raising those limits. And therefore, in the overall settlement, I think we came up with a just and reasonable resolution with respect to the residential customers. They are still being subsidized under this settlement.
So here are a couple things that cause me concern, and perhaps you can comment on. Is we have a monthly compliance report that SPS submits to us on delinquencies and customer arrearages. And I'm looking at a copy of that now. And on, and this is one that I think, yeah, this is November 2021 is when SPS submitted this. On November 19th of 2020, the total delinquencies were 4.7 million. On October 21st, 2021, the total delinquencies are $11,117,000. And they've been going, you know, there's some ups and downs, but they've been going up pretty steadily. Would you agree that that's a sign of some financial duress for those customer classes?
Certainly there is an impact, but I do think also the customers were behaving to the signals when we had a moratorium on disconnection. We had a number of customers that were paying nothing. Certainly they could have been paying something. And so what happened is they pushed themselves into further arrears. And so now what we're doing is we are sending disconnect notices, but we're also working with the customers and working with the state and distributing the ERAP dollars that are coming from the federal government.
Sorry, the ERAP?
ERAP. I forget exactly what it stands for. But we are working very closely and actually getting with the customers so that we can submit their applications to the state for them. So we're working very hard. I think I'm very proud of what we're doing for our customers that are delinquent. The state then evaluates whether they qualify. But I think a large function of this, Chairman Fishman, is that the customers had this moratorium and some of them took full advantage of it.
But you would agree, well, maybe you won't. It seems to me that if there were 4 million in arrears and now that's gone up to 11 million in arrears, they're going to have more of a struggle catching up today, regardless of the reason. They're going to have more of a struggle to catch up than they had a year ago.
No, I disagree.
So it's not going to be harder for them to pay off 11 million than it is for them to pay off 4 million. Is that what you're saying?
Considering the federal government's paying a big chunk of it, no, I don't. Plus, I think they should be paying their bills each month and taking, paying part of their bill or paying all of it. We've worked on and worked with customers constantly on making payment arrangements to avoid disconnection. And so part of it is the customer said, yeah, we owe it to you. Can I pay it out over 6 months? And we say, yes, here's your payment arrangement. You can work that out. So that's reflected in the numbers that you're looking at. But they should be paying something instead of nothing.
And when did you start doing the notices of delinquency?
It was in the August timeframe of this year. And we have various thresholds. We start with like customers that are over $1,000. And then over time, we start stepping it down because we're trying to manage it down. And that's where we're at. So now we're back to, just in the last week or two, to our normal disconnection threshold. I forget exactly what it is, but basically we don't roll a truck unless the customer's balance has gotten above a certain threshold.
Unless the customer's
balance has gotten above a certain threshold. I'll try to slow down for you. I'm sorry.
So in August, let me see. Oh, that was August of 2000 of this year?
Yes, Mr. Chairman.
Okay, so you've just begun. We haven't seen the impacts of that yet.
No, and then like I said, we're also working with the customers. We're getting them to sign a permission that we can work directly with the state to get the ERAP dollars credited back to SPS and therefore to their accounts. And so we'll be seeing more in that reflected as the state catches up.
Okay. And by the way, thank you for, helping customers try and take advantage of the federal programs. Sometimes it's really hard to get them plugged in, and that's obviously the best resolution for all of us. So,
yes, sir. I think it's something that we're doing extra. I think other utilities are doing the same thing, but it's in the end, it's benefiting everybody.
So in terms of total customer rates, I'm going to use the chart that's currently up on the screen, which is from the stipulation and I'm going to use residential, but it also applies to the point applies to small general service. We're talking about an approximate 11% increase. A couple of years ago in the last rate case, my recollection is, and I haven't looked this up, is that there was about a 4% increase for residential, 3 to 4%, somewhere in there. Is that correct?
I do not recall.
Okay. Well, perhaps an upcoming witness will be able to answer that for us. It's certainly easily available information. Is it true that you also have a grid modernization case on the docket that also has rate increases?
It does. We do have a grid modification application that is applying to our advanced metering infrastructure, and it does have a rider included in it.
And when I last looked at that case, the proposed rider for residential was about 7%. Do you happen to have any recollection of those figures in your head? But again, it's easily available information.
I do not have those in my head, Mr. Chairman.
Okay.
Of course, we will not be installing the meters for a couple of years, but it's not like it's today. But I do I do not know the number.
Okay. But I will just state as an estimate, and we can pull these numbers up from the record later or get them from another witness, that if I add those three numbers together, 10%, 11% plus 4% plus 7%, that over the course of a couple of years, the total rate increase for a residential customer on their bill would be somewhere around 20%. Again, rough numbers, I'm not trying to be precise. Presuming that I am correct in my numbers, would that be an accurate statement?
Well, I think it's sort of mischaracterizing what's going on. I mean, you're looking out into the future. We could be seeing fuel cost decreases. I don't know. Certainly we'll have another base rate case next year for the wholesale drop off that the parties and the commission agreed to us to exit the wholesale business. But as far as the grid mod, that's several years out. I don't think that's appropriate to include that in these numbers.
Bills have also risen substantially because of core inflation that has certainly impacted fuel costs. Would I be correct to say that?
Yes, we talked about that earlier this morning. But we're also seeing inflation on labor, on materials and supplies. We're actually getting to the point where we're having a hard time finding certain supplies because of material shortages.
And in addition, in the next year or so, if I understand the testimony that's been submitted correctly, there'll be another rate increase requested, another rate case. Would it, as a practical matter, it looks like there's going to be a super steep increase in residential bills as a result of all these factors. Would you agree that that's the case?
I think if you were to fully unmitigate residential, that could be, in some people's perspective, true. I don't know that I agree with that. I don't think the next increase is going to be as big. Basically, it's reflecting that we are exiting certain wholesale contracts with the New Mexico co-ops. But that also creates fuel savings. That's one of the reasons why we're getting out of these wholesale contracts is it reduces our system average fuel costs, the benefit of all retail customers. So I don't agree with your characterization.
And again, acknowledging you don't agree with my characterization. Well, actually, I'm not going to even go there.
Mr. Chairman, if I might just make inquiry of you,
Sure.
how much more time do you believe that you're going to need for Mr. Hudson?
God, probably 30 minutes.
Okay, it might be appropriate at this point for us to, for the benefit of all, for us to take a brief, it's about 10:45 right now. So let's take a brief 10-minute recess and then you can come back and continue, sir.
Yeah.
Very well. We're going to take a 10-minute recess. Thank you. And
Thank you.
just everyone remember the YouTube stays on. So you're going to want to, if you don't want it on the YouTube, you're going to need to mute yourself. Okay. Thank you.
Thank you.
Okay, I believe we are back from our recess. And Commissioner Fishman, Mr. Chair, you have more questions.
Yep. Sorry, folks, this is the long one right here. After
And
this, things will move much quicker.
would you like me to continue to screen share, or have you completed your questions on the exhibit?
You completed the questions there. Thank you.
Okay, thank you, sir. Please go ahead.
And also, I could use your help on the items that I just asked questions about, the case for grid mod and the prior rate case, where Mr. Hudson couldn't remember the figures. Is there a way I can bring those into the record without having to recall the witness? I haven't had during the break, I didn't have a chance to pull them up and take a look on our e-docket.
And you want those case numbers in the record, Mr. Chairman?
I guess the case numbers, but I also wanted to reference the actual rate increase from the last rate case for residential and small commercial. And I also wanted to take for residential and small commercial the proposed rate increase for grid mod.
Mr. Du Bois, do you have that information of the applicable case numbers?
I do not have it in front of me, Your Honor.
Okay.
Perhaps during lunch, I can even get on to e-docket and quick pull up that information. I just want to get it on the record.
Mr. Du Bois, considered a bench request to find out SPS's last rate case and what the residential and small who?
Small commercial, small business.
What those rate increases were? Any objection to doing that, Mr. Du Bois?
Your Honor, no objection to doing that. We continue to have the ongoing challenge of having the issues go outside the record and into things that are not part of the record in this case, and are actually in at least a couple instances outside the notice of this supplemental proceeding, but we will respond to the bench request.
Very well. And can you also come up, Mr. Du Bois, with your grid modernization case number?
Yes, Your Honor.
Very well. Go ahead, Mr. Chairman.
Thank you, H.E. Hurst. Appreciate it. Thank you, Mr. Du Bois. I'm going back to the current residential customers bill. Is there currently a rider on there to, or is there, I guess it's a rider, to cover the cost of the February weather event?
Well, there's the cost of the February increased gas costs are being amortized over 24 months. through
I'm
the
sorry,
FCC.
sir. Your voice is muddled. There's the cost of the February increased gas costs.
Are being amortized over 24 months through the FEP-CAC fuel clause as approved by the commission.
Okay, thank you.
Excuse me, you're saying fuel clause, correct?
Yes, sir.
Thank you very much.
So again, that's yet another cost that is on the customer's plate, this one in the short term. That, you know, I think speaks to the idea that there is some real financial distress for some of these folks. And boy, the utility bill isn't helping. And it's not your fault, Mr. Hudson. I'm just pointing out that's just the way it is.
Yes, sir. I'm very proud of how SPS performed during the winter storm Uri. We were able to keep our generation above our load and sell excess power into the marketplace and bring those benefits back to our New Mexico customers. So while there were increased fuel costs, they're not near like what you have seen with other utilities in ERCOT or in the Southwest Power Pool. So again, I'm very proud of our performance on our customers' behalf. But the fact is, it's natural gas costs during that event blew through the ceiling because of the lack of supply of natural gas.
And I agree and applaud your performance, and you should be proud. And I will also acknowledge that Sagamore and Hale are exactly the kind of thing we need to prevent those kind of cost spikes from emergencies that we experienced. So again,
Yes,
kudos to you.
they help, but they're still intermittent resources.
Yep.
You know, they actually, Sagamore performed reasonably well, but I can remember that Monday morning when it was minus 12 degrees, there was not a breath of wind outside. But later in the day, it came back and it created a lot of fuel savings for our customers.
Exactly. And I can even I'm seeing if I can edit out a few of these questions. Cool. I wanted to get back to the question again. This may have been covered. My notes are a little incomplete here. This may have been covered by Mr. Grant and not by you, so tell me. I wanted to explore a little more the issue of the cost allocation, whether it's from Sagamore and whether it should be energy-based or not. Did your testimony cover that?
Yes, it did.
Okay, so I'll take a couple minutes on that. So the record in 17 44 and if quite frankly in your testimony is super clear, I believe, that capacity was not a consideration in any way, shape, or form in that asset acquisition. Is that correct?
At the time that, I'm assuming that that docket number is our CCN case.
That's your
sorry.
CCN case.
I
Yeah.
can't keep track of all the docket or case numbers.
So think what it's like for me.
No, I know.
Several utilities.
I understand. And I love it when some of my staff get and start rattling off. Well, remember we did this and now it's like, I don't know what you're talking about.
That's what general counsel always does to me.
Yeah.
That's the way they try to snow us.
Well, I'm not snowing you.
No, no, that's okay. Go ahead.
Okay. I'm very serious.
Yeah.
So in the CCN case, it was predicated on energy savings, mainly because at the time we did not have a capacity need, and therefore we were not identifying.
I'm sorry, I lost the word. Did not have a
capacity need. And therefore it was based on avoided fuel and ETC savings.
Okay. And from the way you answered that question, it sounds like that situation might have changed. Is there, let me ask it this way. That's a poorly phrased question. Is there a need for Hale and Sagamore capacity currently on the system, or is that excess capacity that it provides?
I don't think it's either. It's not excess capacity. I do not think it's it was being built at the time for capacity. I do think at such time that we do have a capacity need, then we would attribute the appropriate capacity rating as determined by the Southwest Power Pool. And they just, in the last 2 weeks, have lowered the capacity accreditation for wind.
Yes, I saw that in your testimony. Mr. Du Bois, do you have a copy of that loads and resources from the IRP? And it's just something I want to talk from to just get a better idea of where the capacity situation is moving for SPS.
Your Honor, I do. I'm not sure whether Mr. Hudson has it in front of him.
Is it possible for us to get that shared?
I have it, Mr. Chairman. I have the table 5-1 from our 2021 integrated resource plan.
Okay, so you're doing better than me. I'd relied on it coming up on the screen, but I'll just go by recollection and you correct me if I'm wrong. And others, if you need to see it on the screen, let us know.
Mr. Du Bois, can you email it to me, please?
I believe so, Your Honor. I also point out that this is a subject of Mr. Grant's testimony and not Mr. Hudson's. I guess
That's why I asked.
is.
And I'm perfectly fine to wait for to do this with Mr. Grant instead. If that's the way you guys would prefer to do it.
Mr. Du Bois?
I was simply observing. I will email that to Your Honor.
No, I'm saying, is it SPS's preference that questions concerning the subject area, since you claim they were in Mr. Grant's testimony, that you wait for the chairman to ask Mr. Grant those questions?
I guess it would be my perspective, Mr. Chairman, Your Honor, that Chairman Fishman certainly can ask Mr. Hudson, and Mr. Hudson can answer what he can answer, but I just wanted to be clear that that is in Mr. Grant's, and he may be the better witness, but that doesn't mean he's the only witness.
Well, I don't want to waste people's time and cover it twice. And I know Mr. Hudson and Mr. Grant are both very capable witnesses. So if there's one preferred, I'd rather save everyone time.
I'm not going to tell Mr. Hudson he can't testify on the issue.
Why don't you go ahead and ask your question, and I'm sure
you could say if you prefer it. Sure.
Go ahead, sir. Thank you, Mr. Du Bois.
Thank you.
And this would be from the loads and resources table. And I'm kind of going from memory because I don't have it in front of me, and I'm a computer, not very good with the computer here. Was that there was at the time the IRP was done, what was something like 700 megawatts of excess capacity over reserve capacity. Is that what you're seeing there?
When are you talking about? In what year?
Currently, in the most current year.
Yeah, I'm not that familiar with the IRP. You can ask Mr. Grant, but based on the tables I'm showing, it's more than that, and it's largely a result of we've been getting out of the wholesale sales contracts because it creates fuel savings for retail customers, and B, we have been acquiring quite a bit of renewables, and some of them do have a capacity value. So once you attribute some capacity value towards those, it drives up the perception that we have excess capacity.
Okay, the perception or the fact?
Well, I mean, it's like I said, it's debated, and now the SPP has come back and determined that wind resources, you don't have to ask Mr. Grant about solar, but that they're not as dependable as they previously thought under the criteria. And so it's coming down. So that's why I say that.
Okay. And on the chart at that time, not saying it's the current reality, but at the time that was done, my recollection is that it didn't, if you looked at that capacity excess over time, it shrinks over time for various reasons, and that there wouldn't, under the scenario on that particular chart at that time, wouldn't need a new resource to come online till 2030 or 2031 in order to meet capacity needs.
Yes, that's what it shows in the tables that we provided at that time under the base forecast. If you look at a higher load forecast, we would be short around 2028.
Okay.
2021.
28,
Thank you.
2028.
Thank you.
Yes, sir.
So I have kind of a philosophical concern here. And you can tell me whether you think I'm getting into the ether or not. But I am concerned that if there's any, well, let me start this way. We've got this asset and there's so we're looking for the loads and resources table. I'm not sure which appendix that is.
Mr. Chairman, Your Honor, we could either go to page 43 through 46 is probably the best place to try.
Okay, thank you.
I'm sorry, in the main portion of the document. This is down in Appendix B right now. So probably closer to page 48 or something of the PDF would be my guess. I think we just passed it. A little higher up.
Derek? Is that what you're looking for,
Sorry.
Mr. Chairman?
We need to go a little bit higher up, Your Honor. That was further out in the future. I think
There you go.
This is the low load forecast. So now you need to go up some.
Go to the medium if there's the 3 scenarios there.
A little more. This is it. Base case forecast.
Okay.
Oh, okay. So we're looking at resource position at the bottom row, correct?
Mr. Chairman, that's correct.
So for 2022, resource position long, it's 1,000 megawatts. 2025 at 770, and 2030 it's 101. Am I reading all those correctly?
Yes, sir. You appear to be reading those correctly.
Okay. And so with what's happened in the intervening time, you probably don't have exact numbers. Maybe you do. How might that have changed?
I would expect that, and I do not know for sure, you need to ask Mr. Grant, that the line up near the top, about a quarter of the way down, purchase power, renewable resources, that line has probably gotten smaller. So our resources have gotten smaller.
Okay. But would you say they've shrunk enough to materially impact the excess, and how much might in a range, because it sounds like you're still trying to figure it out. Can you give some kind of range about how much the long position might be reduced?
I do not have a range. I just have been informed that we would have a need in the 2028 timeframe.
Okay.
Under this base forecast, which
Okay.
naturally under a higher load forecast, it would be even sooner than that.
Okay. So here's the issue I'm wrestling with is if there is no need for the capacity, that this purchase, if the purchase was not predicated on capacity, and if there's no need for the capacity, how do we justify a charge based on capacity to customers? As a commissioner, I'm concerned that we're setting a precedent that we can just throw out the record and charge for stuff that was not needed by the customer.
Mr. Chairman, first of all, I don't think that we are charging customers as a result of the settlement for the capacity.
Okay.
It's part of the overall give and take of all the various issues, including the rate mitigation. And second of all, we're not establishing any precedent going forward on whether this is on energy or capacity. So, you know, I don't have those concerns at all. We are, you know, as I stated in my testimony, you can't say that this is being allocated on anything other than energy. It's a black box settlement taking into account the range of values from very sophisticated parties and settling these big issues that we have in the case.
Mm-hmm. If going forward, if and when that capacity is needed, would you at that point think it appropriate to start allocating via capacity between rate classes?
Sorry, Commissioner, the end of that statement.
So going forward, would you think that it at a point that capacity is needed and being used, would it then be appropriate to allocate those costs via a capacity calculation rather than, or at least incorporating a capacity calculation rather than doing it as fully an energy allocation?
It's my professional opinion that at that time we would take a look at it and give it the appropriate weighting. I don't, you know, that's my view.
Okay. Thank you.
But we're not establishing any practice or principle in this case to warrant it one way or the other.
Mm-hmm.
So I don't think it's binding you or anybody else in the future.
So if you don't believe we're charging for capacity, and actually there's a couple of testimonies we've got now, I'll be asking folks. It feels like you could come up with the same, you could probably come up with the substantially similar result while you do set a precedent that we follow what the record from case 17044, Hale Sagamore CCN, excuse me, and set a precedent that until capacity is needed, we'll make it an energy charge. Would you be willing to do that?
No, I don't think it's necessary. I think you also put some words in my mouth. I didn't say whether there were demand or energy in there. The agreement was we agreed to the black box distribution of revenue increase based on a multitude of issues, including the allocation, the rate mitigation, other issues. And so you can't say it's one way or the other in this settlement. I know how I filed it and I know how I proposed it or how SPS proposed it, but it was under serious disagreement by various parties.
Okay, so to be determined, but you don't feel it's important for the commission to understand kind of the details of how that was built. Correct?
I do not think it's necessary. And even if they did establish here, I think it could be subject for dispute again in the next case. I don't think the commission nailing it down in this case precludes it from also being raised in the next case. I think you're putting too much weight into having to resolve that right now. I don't think it's necessary at all. I think the settlement is just and reasonable as it is.
Okay. Actually, probably, let me look here one more time. I think I may be done with you. Thank you for your patience. I'm just taking a quick check here. Okay, thank you very much. I appreciate your patience with all my grilling here, and thank you for your testimony.
Oh, you're welcome, Mr. Chairman.
Okay.
Thank you, Mr. Chair. Commissioner Hall, do you have any questions for Mr. Hudson?
Thank you, Madam Chair. No, I do not.
Thank you, Commissioner Hall. And again, parties had indicated to me that they had no questions for the witnesses. However, this is going to be your last opportunity. Were there any cross-examination questions from staff or the interveners? If so, indicate now. Mr. Lee, if you could have the record reflect that no one indicated they had questions. Mr. Du Bois, would you like an opportunity to redirect your witness?
I would. Thank you, Your Honor.
Go ahead, sir.
Thank you. Maybe Mr. Hudson, if we start with what's still on the screen, the loads and resources balance, summer 2022 to 2031 base case forecast. Do you still see that?
Yes, I do.
Picking up on, I think there were some references, not sure it was explicit, to the planning reserve margin at 12% piece of that. Do you see that?
I'm sorry, to the planning reserve
margin at 12%.
Yes, I see that.
Are you generally familiar with that?
That concept? Yes, I am.
Whose requirement is that?
That is under the Southwest Power Pool in the North American Electric Reliability Corporation.
Is that 12% requirement a minimum, a target, or a maximum, or none of those?
I do not know. You'd have to ask Mr. Grant.
Okay. Then I will move on. There's been some discussion between the chairman and you regarding the precedential value of any resolution of matters in this case. And you used the phrase, it doesn't, in your view, establish practice or principle. Do you recall that?
Yes.
I'd like to ask you about the hypothetical scenario where, actually, let me start that one over. I'll start with asking you, was any rate design or class allocation matter that was resolved in the last case binding on the commission in this case?
No.
In general, can a commission in one case bind a commission in a future case on a settled or litigated result other than a prudence determination?
No, that's my understanding is they cannot. And if they have a basis for changing something, they can do so.
So for thinking about what a set of commissioners hearing SPS's next case, including commissioners who are sitting today or commissioners who are not sitting today, would any of them be bound by a determination on allocations in this case?
It is my understanding they would not be bound.
Moving on again, there was some discussion about the impacts of other cases, which we're working on getting the case numbers of, on customers. Do you recall that?
Yes.
Actually, I may have the case numbers now. Your Honor, Mr. Chairman, I would report back the SPS grid modernization / advanced metering case is number 21-00148-UT. And SPS's prior rate case is case number 19-00170-UT. And I don't memorize case numbers either, so. Still remember the first three I ever did, and I stopped there. Mr. Hudson, picking up first on the grid modernization case, are you generally familiar that there was a cost benefit analysis that was done by SPS in support of that filing?
That is my general understanding, yes.
Are you aware whether the cost benefit analysis indicated a net cost or a net savings to customers if that grid modernization proposal were implemented?
My general understanding is it was a net benefit.
I'm sorry, I didn't.
It was a net benefit.
Okay. Would a net benefit to customers equate to a net savings for customers?
Yes.
Going to give you another memory test, perhaps. And if you don't know, you don't know. But referring back to SPS's 2019 rate case, do you recall how the revenue requirement in that case, the resulting revenue requirement increase in that case, compared to the then applicable hail savings analysis at the time?
My general recollection is there were more hail production, fuel, and PTC savings than the cost.
I'm sorry, production
But they were more
hail.
hail, HALE, fuel, avoided fuel, and production tax credit savings than revenue requirements for the hail project. There were more net savings than costs.
And would hail be generating more savings or less savings for customers now than it was at that time?
Given that the avoided fuel costs have increased, there would be even more savings today than there were at that time.
So while neither of those are an issue in this case, would you agree or disagree that neither of those yield a net rate increase to customers?
Neither of those two avoided fuel calculations?
Sorry, the grid modernization case, nor the rate case.
That's my general understanding.
Changing topics again. Regarding the last SPS rate case, that 19-00170 case, are you aware whether that was primarily a black box case settlement as well?
I am aware that it was.
Are you aware of whether there were any public comments or complaints regarding the black box nature of that settlement?
I'm not aware of any, and I think I would have been if there were some.
Are you aware of any that were reported to the company by the commission?
No.
In the 5 months, approximately 5 months, the stipulation has been pending in this case. Are you aware of any customer comments or complaints regarding the black box nature of this stipulation?
I have heard of no complaints.
Without getting into the details of any settlement discussions, are you aware of any persons who were parties to the case or otherwise sought to be included in the settlement discussions who were excluded from those discussions?
I have not seen or heard of anybody that was excluded that wanted to participate.
I think one more topic, Mr. Hudson, Your Honor, Mr. Chairman. There was some discussion earlier about the share or what about the share of the revenue requirement increase specified in the stipulation that Sagamore constitutes. Do you remember that?
Yes, that was at the beginning.
Do you have a copy of the stipulation in front of you by any chance?
Yes, I do.
Could I please direct your attention to pages 3 to 4 of that?
Which page?
Pages 3 to 4, the section
Okay.
1, agreement as to base rate increase.
I'm
Yes.
sorry, section 1.
Agreement as to base rate increase.
Yes, I see it.
Okay. In that, there is a revenue requirement stated for each of Sagamore and Hale. Is that fair?
Yes, in paragraph 7.
Do you know why those needed to be stated?
Those are to be used for the 10-year savings test so that we can track the fuel savings and PTC savings compared to the revenue requirements for a New Mexico jurisdiction.
And
You're saying P, you're saying P as in Peter, T as in Tom, C as in capital?
Correct. Production tax credits. Yes, sir.
Thank you very much.
Yes, sir.
And could you refer to the next paragraph, paragraph 8?
Yes.
Let me know when you're ready.
I see it. I'm looking right at it.
do you have a perspective on whether the unspecified adjustment in the amount of $14,958,155 can in part or in whole be attributed to the share of the actual revenue requirement in this case that's attributable to Sagamore and Hale?
Yes, I think certainly different parties can look at it differently, but my view as part of that 14.9 or 15 million could be attributed or ascribed to the Sagamore revenue requirements. And I think I've actually included that in one of my work papers.
Do you want to take a moment to see if you have that?
Yep. Yeah, it's on page 3 of 8 of my work papers. So basically what I'm saying is if you ascribe a pro rata amount, you know, everybody can argue that that was the black box agreement and the unspecified adjustment that could go towards various issues. It would reduce the revenue requirements from 38 million to $30.7 million on a New Mexico retail basis.
So to be clear, is it your opinion that the savings test revenue requirement for Sagamore has to be the same or could be different than the share of the actual revenue requirement that a party could attribute to Sagamore?
I'm sorry, I didn't follow your question.
Yeah, that's poorly framed. Or actually, let me try it this way. Can you maybe explain how it can be both true that the savings test revenue requirement you described for Sagamore of approximately 38 million?
I'm sorry, you're breaking up. Let me try it this way.
Can you please explain how it is both, or how it can both be true that the savings test revenue requirement for Sagamore is 38 million, approximately 38 million under paragraph 7 of the stipulation, and that you were able to calculate in that work paper, page 3 of 8, a $30.7 million representative Sagamore revenue requirement in rates?
Yes, for purposes of the 10-year test, it's in the customer's interest to get the highest reasonable revenue requirements for Sagamore and Hale to test for fuel savings. That's in the customer's interest to get the highest one. But when looking at the overall settlement and the dollars that were given for the various issues in the case, I do think part of them should be ascribed to the Sagamore revenue requirements. And that's the way I looked at it. It's in the customer's benefit both ways. For the fuel and production tax credit savings test, having a higher revenue requirements means you've got a higher hurdle to get over. Improved savings for customers.
Thank you, Mr. Hudson. Thank you, Your Honor, Mr. Chairman, Commissioner Hall. That's all I have.
Mr. Chairman, any further questions for Mr. Hudson?
Yes. Really just one, regardless of Sagamore and Hale saving customers money, which I agree to. I think they're great projects. We spent a lot of time defending them, and frankly, I'm all for them. I think they're great, and admire the company's initiative in putting those deals together where others have not. But I'm going to come back to the residential and general service customers in particular, but it applies to all customers, is whether or not people agree that Sagamore and Hale save folks money or grid mod saves folks money. The filings that we've made or that have been made increase the customer's bills, both the current rate case that we're talking about and the grid mod rider. It's not a negative rider, it's a positive rider. Is that correct?
Yeah, first of all, let's talk about the rate case. There are other costs besides Sagamore that are included in the case. We put in a lot of distribution. In fact, we were really worried we're getting ready to burn down circuits in the town of Carlsbad. We were overloading substations because of the growth that we're seeing in residential and small general service just in the town of Carlsbad. Same thing with Loving. We've added
residential and small commercial service.
Yes, in that community, as well as
I think your line is sort of muddled. Residential and small commercial in that community.
Yes, and then I'll continue now. As well as the communities of Loving, Hobbs, Roswell, Portales. We've been making upgrades, especially as we've got some very low voltage, old, 60, 70-year-old distribution lines that need to be upgraded. We need to also take into account that as people are starting to clean their emissions profiles, they will be using more electricity, and it's going to put more and more stresses on the transmission and distribution system as the transportation sector electrifies, as industry electrifies to reduce their emissions profiles. What that means is you're going to see more and more investment in T&D. I think we can look at dispersed generation, but the cost of that, if you look at a solar profile throughout the day, it goes up when the sun's shining. But if you see a profile of a farm, you will see clouds come in and diminish the production of that farm by 30 to 50%, depending on the cloud cover throughout the day. So how's the system going to respond to that? You've got to consider all of that. But the point is we're making a lot of investment in our system to serve load growth, especially in these communities that are growing. The second thing is, I've lost my second point. Oh, on the grid mod. We are putting the AMI cost into the grid mod rider, but the savings by no longer having meter readers going out and reading these as often, that's going to be reflected in lower O&M that's in a base rate case. So you got to be careful you're not conflating how these all interact with each other. You can't just say, oh, rates are going way up, but ignore how savings are being flowed back, whether it's through base rates or through the fuel and purchase power cost adjustment clause. It's all interrelated. It's very complex.
I take your point, but if in the case of grid mod, and I may be wrong on this, and correct me if I am wrong, it feels to me like in the proposal, the rider hits, but the benefits may not come for a couple more years. And they still want, and that it won't be until a subsequent rate case that whatever those savings are might get reflected, so that in the short term, the customers do take a hit on their bill, even though in the longer term, it gets reduced.
Well, Mr. Chairman, I think you're hitting my point from the very beginning about regulatory lag. The regulatory lag seems to go way against the company and the investor than it does the customer. But ironically, you're arguing that this one little piece, there may be some regulatory lag associated with it.
Well, I'm not, yeah, and by the way, I am not unsympathetic to your regulatory lag, or at all unsympathetic to the benefits of getting this particular case settled quickly, because that's a lot of investment to sit on without getting a return. So
Not only a return, but we're not getting a return of.
yeah,
We're not
no,
getting the depreciation. I mean, it's a big chunk that's slipping all the way down to the net income before tax.
no, I totally get your point, and I totally get your point about regulatory lag. And
Yeah.
I'm not unsympathetic, and I would, it's something we can all work on improving. So, just so you know.
Yes, sir.
And if you guys come up with great ways to help address that situation, I'm certainly open to it. So, anyway, that's my only question.
Commissioner Hall, any questions for Mr. Hudson?
Thank you, Madam Hearing Examiner. The few questions I had were asked and answered, so thank you.
Thank you.
Mhm.
Any further follow-up, Mr. Dubois?
No follow-up, Your Honor, but I do have one process issue before Mr. Hudson were to be excused.
Yes, sir.
SPS had filed its responses to bench request 7 as a separate piece versus Mr. Hudson's testimony or Mr. Grant's testimony.
Yes.
Mr. Hudson was a sponsor of one of those responses.
All right.
I don't know how we want to handle that as an exhibit, whether it would be okay to move the whole package in at once, or whether we want to do the piece, the specific responses with the specific sponsors. Mr. Hudson sponsored number 7B. Mr. Grant is a sponsor on both A and C.
Mr. Hudson, Mr. Du Bois has indicated that you were a sponsor to bench request 7B. Is that correct, sir?
That's my understanding. I do not have it in front of me. I do not have that.
Request 7B generally indicated that you needed to provide summaries of arguments regarding class allocations for rates, an explanation for why there was an agreement to that, and a discussion of whether the allocations in the original applications were superior or inferior to those in the stipulation. Are you familiar with that request?
Yes, Madam Hearing Examiner, and I just looked at it, and all I do is refer to my supplemental testimony that just filed. So it's all in this testimony that's in exhibit.
Very well. And the answers are the reference that you gave to the testimony is accurate?
Yes.
Okay.
Yes, Your Honor.
And you just answered it last week, but if you answered it today, would your answer be the same?
Yes, it would.
Okay. I think that's fine as far as 7B. Does anyone have any objection to this part of SPS exhibit? Hearing none, we'll hold a ruling on admitting it until I get the other complete parts, Mr. Du Bois.
Thank you, Your Honor.
Thank you. Very well. Then if we have no further questions for Mr. Hudson, thank you, sir. You are excused. And I will ask the chairman, do you have an approximate length of time for for witness Grant?
5 minutes?
Oh, well, let's push on then, if that's all right. And Mr. Du Bois, would you call your next witness, sir?
May I have just a minute, Your Honor? He is actually here in the same location, but I think YouTube lags by a moment, so I can go bring him
Okay,
in.
very well.
I'm back, Your Honor, and have Mr. Grant as well.
Very well. Good morning, Mr. Grant.
Good morning or afternoon here.
Aha. Almost here. Mr. Grant, do you remember testifying in the case in chief in the rape case earlier this summer?
I do, Your Honor.
And you remember you were under oath at that time?
I do.
Okay, and I would remind you that in our reopened proceedings that you are still under oath, sir?
Yes, ma'am.
Very well. Mr. Du Bois, you have another witness.
Thank you, Your Honor. Mr. Grant, you have in front of you a copy of a document titled Testimony Pursuant to November 3, 2021 Order in Support of June 23, 2021 Uncontested Comprehensive Stipulation of William A. Grant on behalf of Southwestern Public Service Company, dated November 12, 2021.
I do.
And was it prepared by you and under your direction and supervision?
It was.
Is it true and correct to the best of your knowledge?
It is.
Do you have any corrections?
I do not.
If you were asked the same questions today, would your answers be the same?
They would.
Your Honor, I would move the testimony as SPS Reopen 2.
Any objection to what's been identified as SPS's Reopen Exhibit 2, Mr. Grant's testimony filed pursuant to the commission order? Hearing no objections, SPS Reopen 2 is admitted. Anything further, Mr. Du Bois?
Maybe we can do the bench response as well now, Your Honor.
Very well.
Mr. Grant, do you recall there being a bench request number 7 that was made by the commission?
I do.
And did you respond to bench request number 7A and bench request number 7C as a sponsor?
I did.
And were those prepared by you and under your direction and supervision?
They were.
Do you have any corrections to those?
I do not.
Are they true and correct to the best of your knowledge?
Yes.
If you were asked the same questions, would your answers be the same?
They would.
And Your Honor, given Mr. Hudson's earlier answers and Mr. Grant's present answers, I would move the entirety of bench request number 7, SPS's responses to bench request number 7 in as SPS reopen exhibit 3.
Any objection to what's been identified as SPS reopen exhibit 3 and has been verified here today, both by Mr. Hudson and Mr. Grant, who were sponsors? Hearing no objection, SPS reopen exhibit 3 is admitted.
Thank you, Your Honor. Mr. Chairman, Commissioner Hall, Mr. Grant is available for questions.
Very well. Mr. Chairman, you have questions for Mr. Grant.
Just a couple. First of all, Mr. Grant, thank you for your more than thorough answer regarding upcoming potential rate cases. And it helped get me a little more informed on the whole landscape of what's going on with SPS. So I appreciate your thoroughness and openness in those answers, even if you sounded a little annoyed, which I understand. Were you listening to Mr. Hudson's testimony?
For the most part, yes, sir, I was.
Prior to coming in. And so there was only one issue that I really wanted to touch on with you. And as Mr. Du Bois correctly pointed out, you focused on it more than Mr. Hudson in your testimony. And that's this whole capacity issue on Hale and Sagamore. And I guess what I think I'll just step back here and say, is there any additional information based on what you heard that we need to know, or that I should know or understand regarding that allocation of cost by capacity versus energy?
As far as the answer Mr. Hudson gave you about the stipulation, I think he was accurate that it was part of the discussions, the give and take between parties. I think there was one question about the 12% reserve margin. And I will say that the 12% reserve margin in the Southwest Power Pool is a minimum recommendation. It is not, you can't go below 12, but you can be above 12. And one of the things that I would have pointed out, if you look at the capacity margin on row E, you will notice that for the projected load in the first table, is requirement-wise is about 476 for 2022. One of the things I will point out, and I have done it in testimony as well, is that does not even equal my largest unit. So if I was to lose the...
I'm sorry, sir. One of the things I want to point out,
that the 476 does not equal, is less than my largest unit. So for example, if my Hobbs generator, the combined cycle generator, is out of service, I would not have, if I got all the way down to 12%, I would not have enough capacity to even meet my daily operating reserve requirement. So that is why it's very important to understand we do show the minimum requirement on our L&R table, but I have testified before that I don't think it would be prudent for SPS to actually get all the way down to that number.
Understood.
The other thing that has changed is the Southwest Power Pool in the July board meeting adopted the what's called the expected load carrying capability, or commonly known as ELCC methodology for accreditation of wind. And what that does is that takes into consideration saturation, as I put in my supplemental testimony, of specific resources. And this table does not reflect that, but all of our thermal resources, and by the way, that's not nameplate on this table, it's accredited capacity. But that has been reduced by quite a bit, about 250 megawatts. The other thing that I will say is whether we need the capacity or not, SPP is now giving accredited capacity to all resources, whether or not it has firm transmission or not. If you do not have firm transmission, it's a lesser amount, but they consider all resources having a certain level of capacity.
Okay. Thank you. So that answer just prompts a question that I think I know the answer to, but think is not knowing. Is there anything about the Southwest Power Pool, your relationship with them, that impacts the evidence in this rate case? Does that Power Pool membership in any way color the evidence or things that we need to consider? That's a pretty broad question, pretty bad one, but I'll let it lay there while I think of something, think of phrasing it better.
I would prefer you to phrase it differently because that is such a broad question.
Yeah. In terms of rate base, and in terms of calculating the rate base and including assets in rate base, does your Southwest Power Pool relationship affect how we make those determinations? I know it affects your resource mix, but does it affect how we make determinations about what to put in rate base and how to, establish the return for it?
If your question is driven towards resources, the answer is the only thing as Southwest Power Pool requires is that all members of the Southwest Power Pool meet the minimum reserve margin. If you're talking about transmission investment, however, there are things like Schedule 11, even our Schedule 9 fees are in Attachment H of the SPP tariff, and the Southwest Power Pool administration fees are Schedule 1A are also part of charges that we include in the rate base.
Oh, okay. One of those rare occasions where what I thought is actually something I know. So thank you. With that, Mr. Hudson took all the hard fire for you. And that's really all I've got.
Commissioner Hall, any questions for Mr. Grant?
Madam Chair, I would, yes, I just have one question. If he could elaborate a little bit on that capacity credit that he says all members now receive. If Mr. Grant could just elaborate on what that is and how it functions, I'd be interested to know.
Yes, Madam Chair. When you look at the ELCC methodology, it's kind of like a loss of load and expectation study. So you go ahead and build in a lot of different scenarios, and you come up with a accreditation for different type of resources. And it also talks about, real-time operation saturation points in different areas, and it calculates. So there's 3 levels in what is now approved in the Southwest Power Pool for accreditation for renewables. There's 3 tiers. The first tier is the highest tier, to where you have a resource and also has firm transmission, and it's applied to that accreditation. Unlike the past, however, there is a tier 3 in that accreditation, because the SPP criterion to this point used to say that you had to have a firm resource with firm transmission before you could give it any kind of capacity accreditation. There is now a tier 3 that can serve up to any entity's 12%. In other words, up to their reserve margin with resources that are connected to the system but do not have firm transmission, but have been studied to be deliverable to the market through the Southwest Power Pool. And for example, a wind farm that has full transmission might be getting 15 to 16% accredited capacity. A tier 3 resource might only be getting 3 to 4%, but there is some level of accredited capacity if it's deemed to be deliverable.
Okay, thank you very much. I appreciate it. That's it, Madam Chair. I have no other questions.
Thank you, Commissioner Hall. Any redirect, Mr. Du Bois?
I have a hard time helping myself, Your Honor. Very brief, please.
Go ahead.
Mr. Grant, in terms of the capacity position discussion, could you comment on your perspective of whether SPS had, quote, excess capacity in February of this year?
No, and I hate the term excess capacity, and let me explain. We do have resources above the minimum requirement in the Southwest Power Pool. We've had several reasons why the numbers are what they are. We've had a ramp down of wholesale sales. However,
I'm sorry, we've had a ramp down
of wholesale sales.
Thank you.
However, the resources have been very instrumental in fuel savings for the SPS customers. For example, during the Winter Storm Uri, we were able to have our generators running with as much fuel as we could get for and ended up making sales. If we had not had that capacity position, we would not have fared near as well. But there's other things that come into play too. For example, last year when fuel prices and fuel was trapped into the New Mexico oil basin, we were able to burn at sometimes negative gas, but sub $1 gas, sub $2 gas, and in units that would have been otherwise deemed to be inefficient. It was really a phenomenon that we experienced, that where the more inefficient it was when prices were negative, the more you wanted to burn. It's kind of contrary to the normal way of calculating your incremental charges. So we also have what we call, normal maintenance and outages on the system, and anything else that this capacity position allows us to respond to. So I would say no, we did not have excess capacity, but we did have capacity above the minimum requirement.
Thank you, Mr. Grant. Thank you, Your Honor, Chairman Fishman, Commissioner Hall. I'll stop there.
Very well. Anything further, Mr. Chair?
No, thank you.
Thank you. Thank you, Mr. Grant. You are excused. Anything further from SPS at this time, Mr. Du Bois?
No, Your Honor. Thank you.
Thank you. And with that, I think we've reached our luncheon hour. I have 2 different times, one on the watch, one on the computer. To be consistent, I'll go with the computer time, which is 12:15. We're going to take an hour, if that's acceptable with people. We'll come back at 1:15. And I believe, Mr. Chairman, you have questions for our next witness, which would be the Occidental witness, Mr. Pollock.
Okay.
Very well. We are recessed. Remember YouTube, if you want to mute yourselves. We'll be back at 1:15. Thank you.
That's it.
Hello.
Hey,
We are returning from our luncheon recess. And hello there, Mr. Pollock.
How are you?
I am okay. How about yourself?
Long time no see, huh?
Yeah, I know it hasn't been that long, has it?
No.
It seems like yesterday.
It's barely a month.
Let's see. Okay, I guess we're gonna wait for SPS.
You don't need them.
We don't need them. They've already testified.
That's right. They had their say already.
Okay.
The chairman's agreeing with me.
you have a very cavalier attitude towards these folks.
No. Healthy respect, nothing less.
Well, they testified so much that they made it easy on you.
You know, I don't mind.
You only have one
okay.
question to deal with, and then you get to just flip us the bird if you want to.
Oh, no, no.
No.
Absolutely not.
My feelings don't get hurt. Whatever.
Mine neither.
Mine do.
You're such a girl.
Be careful.
I know. I was going right on the edge there.
Yeah. Uh-huh. Mm-hmm. Okay, well, we'll wait a couple more minutes.
Was all that exchange off the record?
Pardon me, sir?
Was all that off the record?
Yes, sir. Yes, yeah, we
Oh,
haven't.
it better be.
Yeah, no, we haven't gone back on. I don't think Mr. Pollock has an attorney yet. I'm trying to look through the faces here.
Madam Hearings Examiner, Mike
Oh,
McMillan.
there you are.
Macmillan saved me.
Okay, he's there. Okay, there's Mr. Dubois. And looks like we still need Mr. Bagatko and Mr. Nelson. And I'll give them 2 more minutes.
Mr. McMillan, do you have a middle initial?
It's A.
Okay, we're going to go ahead and start, and we are back from our luncheon recess, and we've completed the SPS witnesses, we're going to now move on to the Occidental witnesses or witness. And I believe Mr. McMillan, this is your witness, is that correct?
That's correct, Madam Hearing Examiner.
And Mr. Pollock, you testified in the original rate case hearing that we had in this case,
I think I did.
and you are under oath.
Yes.
Okay, I just remind you that in this reopened proceeding, you continue to be under oath. All right.
I'm admonished,
Yeah, well, no, not admonished, just reminded.
reminded.
Okay. Go ahead, Mr. McMillan.
Good afternoon, Mr. Pollock. Do you have a copy of your amended testimony addressing the Commission's 7th bench request order?
Yes.
Mr. McMillan, you were breaking up. Can you start that again?
Absolutely. Mr. Pollock, do you have a copy of your amended testimony addressing the Commission's 7th bench request order?
Yes.
Was that document prepared by you or under your direct supervision?
It was prepared by me.
Do you have any corrections that you'd like to make to that document?
I have just one, a typo at the bottom of page 3.
Okay. And where is that correction?
Line 22, the number 186 should have been 167.
Okay, Mr. Pollock, with that correction, if I were to ask you the same questions today, would your answers be the same?
They would.
Your Honor, I move OPL reopen Exhibit 1 into evidence.
Mr. Pollock, the answers are true and correct to the best of your knowledge.
Yes, ma'am.
And my understanding is that this amendment, that the only change to the amendment from your testimony that was filed on Friday had to do with the inclusion of lines 13
Actually, I think it's the bottom
No.
of page 1, lines 20 through 24.
Okay, thank you. Yes, the question posed on 20 and then your answer 23 and 24. That was the only change from the original to the amended, correct?
Correct.
Okay. Is there any objection to what has been identified as the Occidental reopen exhibit number 1, Mr. Pollock's amended testimony as corrected by him here today? Hearing no objection, OPL reopen exhibit number 1 is admitted. Anything further, Mr. McMillan?
Not on direct examination, Your Honor. We
Very well.
Pollock for cross.
Thank you. Chairman Fishman, you have questions for Mr. Pollock.
Just one question. On page 4 of your testimony, you state that base rates should always be evaluated independently. I might be paraphrasing there from my notes. I wanted to get as clear as possible on what you mean by that. Can you expound?
Happy to, and it's good to finally meet you, Mr. Chairman. So the whole purpose of the rate case is to adjust SPS's base rates. When I say base rates, I'm talking about the portion of the rate that is not subject to separate cost recovery mechanisms like fuel, like energy efficiency, and other things. Because in a rate case, we're looking at a snapshot in time. And in that snapshot in time, everything else is frozen. Fuel clause is frozen, energy efficiency clause is frozen. All those things are frozen. And all we're looking is the impact of the change in base rates, because those are the costs that are changing for rate making purposes.
So there have been today even a couple of statements that for a number of reasons, including distribution assets that are included on residential but not included on transmission level customers, or well, I'll just leave it at that. That's one of the factors. But for a number of reasons, when you switch from fuel-based resources to non-fuel-based resources,
renewable resources, I assume.
Renewable, yes. That's going to, just by the nature of math, increase the rates for smaller customers more than for industrial level customers. Would you agree that's the case?
Well, I think ultimately it depends on kind of where you are in the cost of service study. And by that, I mean, if we were starting, everybody was at cost, and all things being equal, you put a renewable resource in and you assume that that renewable resource is providing some degree of capacity, which all renewable resources do, as well as energy.
I'm sorry, you faded. Providing some degree of capacity.
Right. And energy when these resources are able to do so. And you assume that there's some cost allocation that recognizes those both attributes, then there's going to be a different impact on base rates of different customer classes. Again, assuming we're all at cost to start with. Now, in a rate case, that's seldom is ever the case, but if you make that assumption, that's, you know, the effect of those resources is going to affect different customer classes differently.
So you don't necessarily agree. Let's assume that everybody's at cost of service. If everyone is at cost of service, do you agree or disagree with the proposition that moving to more renewables, owned renewables in particular, will, just by the nature of the beast and how rates are calculated, tend to create less savings for small customers than for large transmission customers?
When you say less savings, can you elaborate on what you're talking about?
Less fuel savings.
Well, because of the fact that smaller users use less energy, operate at a lower load factor, it's essentially it's math. Because if you reduce the fuel charge per megawatt hour, that has a smaller effect on lower load factor customers than it does on much higher load factor customers. It also depends too, Mr. Chairman, on how that fuel factor is designed. You know, if it's designed the way the current factor is designed, you know, the fuel factor could change by the same amount, but because certain classes, high load factor customers use more energy per customer and per amount of capacity, just by math, that's going to have that reduction in fuel price will have a bigger impact on the overall bill of a customer.
Mm-hmm.
All other things being equal, and keeping in mind that those savings have already occurred in the case of SPS when those plants, you know, came online.
Do you see any potential need to adjust for that effect?
Well, I think when you say adjust for the effect, I think the commission always has discretion to apply gradualism, and I think the commission's policy has always been, at least to my knowledge, since I've been appearing before you, and I won't say how many years, but it's long enough. You know, the movement to cost has always been a gradual one, and you know, we're never quite there, but we're always trying to get closer, as close as we can, you know, under the circumstances that prevail at the time that you make a decision. So it's really kind of in your hands to decide how, how gradual to make it. And I recognize that cost is not the only factor. You need to also consider impacts on all customers of different rate changes.
I'm gonna go a little deeper than I first intended, but so bear with me a second. If well, in calculating for cost of service, as we move to renewables, and renewables, basically throughout the day, your capacity is changing based on when renewables can be online or not online.
True.
What does that do to the whole concept of load factor in rate setting, and how do you adjust for that?
That's a great question. Because of the fact that renewables have different operating characteristics, wind operates primarily, off-peak hours and at night. It almost kind of requires you to rethink the rate design a little bit and try to develop rate designs that better reflect the time of use. As an example, and this is not a self-serving statement. A few cases ago, we recommended a SPS implement a time of use fuel factor because it's realizing.
A few cases ago, go ahead.
I'm sorry, we recommended that SPS be required to implement a time of use fuel factor. Why? Because clearly with renewables on the system, fuel costs are not the same in every hour of the year and tend to be a lot more differentiated between on and off peak hours. And so with that, so what I'm basically saying is I think that renewables invite a further discussion on trying to refine the rate designs, not necessarily shift costs between classes, but refine the rate designs that each class has so that they get the right price signals to use electricity when it's the least expensive.
I'm sorry, you broke up again, but define rate design that each class has.
To provide the proper price signals, use electricity when it's least costly.
So say I went all the way with your concept of time of use on fuel, and I said, gee, maybe we should set time of use rates, not just for the fuel, but for the generation as well.
Sure.
Basically, every rate class had the same time of use rates. It's just if you use it at midnight, this is the rate, because that's how our resources fall out. If you use it at 10 a.m., the rate might be different because it's a different mix of resources and a different use of fuel. Conceptually, would that be a direction you could potentially go?
Well, I think within certain grounds, yes. The thing is, you still need to take into account all the basics, right? So you got customers that take service at different voltages. You do have different load factors that affects obviously the cost per kilowatt hour at all levels, generation, transmission, distribution.
Yeah.
You got customers that have more customer related costs and that. So as long as you still observe the accounting for the differences in the way that customer classes take service, and assuming too that you develop a proper allocation of generation costs via time of use. And I think that can certainly be implemented. Now, that doesn't mean that everybody's going to pay the exact same rate per kilowatt hour because of the differences that we just talked about.
Yeah.
And it doesn't necessarily eliminate demand charges because you don't want customers to have the wrong signal. And
I'm sorry, that statement is not coming through. Differences we just talked about.
Right. And you don't want to eliminate demand charges because demand charges send appropriate price signals to customers, not to overconsume at certain times and to manage their loads.
Mm-hmm.
That's still a very important signal to send, no matter what, how much capacity the utility has at a given time.
Okay, so you, without getting into too many details, I'm just conceptually trying to establish how germane our current cost setting conventions are to the case we have at hand.
Yeah.
And I'm looking at the fact that somewhere in the testimony, it was stated that with the addition of Hale and Sagamore, approximately 45% of the energy that's going to be delivered by SPS is going to be renewable.
That's correct. Yeah.
To me, that's a pretty significant impact on the way we look at costing in the vein of the discussion we just had. Would you agree with that or not?
I think it's important to look at it, and I think it's important to give it very careful consideration.
Okay.
As even my testimony in the case says, look, the old methodologies worked fine for the thermal resources, but you really need to give some thought and nuance to the renewables. And the fact that you've got 46% renewable also affects how you allocate the thermal, because the thermal plants are not, operating and providing the same function as they did previously. So you have to take both things into account.
So given that, when we're looking at these cost of service studies that have been done by the parties, how should we, I don't know what to call it, how should we view their, I hate to use the word accuracy, but how relevant are they to the circumstances we're in with 45% renewables at SPS? And what does that mean about how we should evaluate and use those numbers?
I think the cost of service studies provide some important information. I think the parties have basically given you cost studies that I'm using my hands as bookends.
Yeah.
So you got SPS on the one hand that says all the renewable stuff provides zero capacity and it's all energy, including all the purchase power agreements and all that even those that have accredited capacity provide zero capacity and all energy. That's one obviously extreme end of the bookmark. You have the other end that says, no, the renewables are just as integral to the mix as everything else, and we ought to treat all production plant the same. That's the other bookend. If you look at the results of the stipulated increases, you can find that between those two bookends, the results come in between, within that range.
Mm-hmm.
That's why I think you should feel okay about the stipulation, because we've given you kind of the two extreme ends of the range. Now, I'm not suggesting that either one is necessarily 100% right. I think cost studies can always be improved, and I'm happy to have a discussion with you at some point.
Mm-hmm.
But given those two bookends, given where the allocations are falling out, I think you should feel good that they're well within that range. So it may not be the exact right answer, but it's going to be really close. It's going to be, a good mix of taking both extreme positions into account.
But in looking at those two, neither one of them, and this is just one mechanism, it could be many others. You'd suggested the time of use rates. We talked about that. Neither one of those cost of service studies contemplates anything like that. So my question becomes, is the model that those studies are using, does it fit the situation that currently exists at SPS? Or, and I think actually you said this just a few sentences ago, it'd be nice to look into changing that model going forward based on what we see. Would you stand by that statement?
I would. I mean, SPS is proposing to change the model significantly. Now, we don't necessarily agree with all the changes that SPS wants to make. That's worthy of a discussion. But you can only do so much as you can measure. And SPS doesn't have the metering to measure time of use accurately for all customer classes. So it's kind of a futile gesture to try to shoehorn a time of use cost of service study when you have a rate design that just can't be implemented on a time of use basis. But that's not to say that can't be done.
I'm sorry, you're breaking up again. Shoehorn a
time of use cost allocation methodology on a rate design that's not capable of measuring usage on a time of use basis for everybody.
Right. So the conclusion that I'm drawing from that, and I want you to correct me if you think I'm off on a dumb tangent, is that when we get the cost of service studies, we shouldn't take them too literally. It's okay to inform them with some judgment, given what circumstances we see, knowing that we're dealing with an imperfect model.
Well, every model you deal with is going to have some imperfections. I think a cost study provides really good information. I wouldn't say that they're inaccurate at all. I think they give you really good information. What you do with that cost of service study is up to you. I mean, your past suggests that cost of service is an important consideration. It should still be important, but it's not necessarily the only consideration, and we respect that. We understand that. We'd like it to be the most important consideration because it treats everybody fairly and gives everybody the right price signals.
Okay, that's really all I needed to explore, and you're very, very articulate answers. Thank you.
Thank you for your questions.
You're on mute, Judge.
Judge, I like that.
You're on mute, Judge.
Some people might prefer that I stay on mute, but thank you. Let's see. I don't see that Commissioner Hall is with us this afternoon. So, as I indicated previously, parties had indicated prior to the hearing, they had no questions for each other's witnesses. However, if that has changed, now is your opportunity to let me know. And I'm not seeing anyone indicates that that their position has changed. So, Mr. McMillan, do you have any redirect for your witness?
Yes, very, very briefly, Your Honor.
Go ahead.
Mr. Pollack, you were asked about how switching to non-fuel-based resources would impact costs for various customer classes. Could you explain, so in your opinion, would using an energy allocator appropriately track the cost savings that each class would receive from renewable resources like Hale and Sagamore?
Yeah, so let me kind of approach it this way. So to kind of put your question in context, so the reference has been to the CCN case that said that we were able to justify Hale and Sagamore based solely on energy cost savings alone. And while we didn't disagree with that statement itself doesn't really say how should those costs be allocated in a way that recognizes energy cost savings. Because just because the words energy happen to be in both the order and energy cost savings doesn't necessarily infer how those costs should be allocated on an energy basis. The question I think that needs to be asked and explored, and I kind of started to explore this in my testimony in the case, is okay, if the energy cost savings justified the investment, I think we all agree that that's what the order says, and they didn't have, SPS did not have to make the case that it needed capacity because the economics were so good. Then what does that mean in terms of cost allocation? Well, you have to ask the question, when do those energy cost savings occur? Do they occur every hour? Do they occur only at certain times? In my direct testimony in this case, I answered that question. I studied that question and said, look, when you put in a renewable resource, you're going to incur a cost because you can't do it for free.
Look, when you put in
a renewable resource, you're going to incur a cost because you can't install anything for free. Everything costs something. And for Hale and Sagamore, that levelized cost is about 1.9 cents a kilowatt hour. So then you ask the question, okay, well, when do the savings occur? Well, the savings occur whenever the avoided energy cost is above 1.9 cents a kilowatt hour by definition, right? So when do those hours occur? When are the savings greater than 1.9 cents a kilowatt hour? The answer is the majority of the time those savings occur will be during on-peak hours. Now that conclusion may say, wait a minute, how can that be right? Because this is an off-peak resource, how can most of the savings occur during on-peak? Because the costs.
I'm sorry, you're breaking up. The conclusion may be, wait a minute.
Yeah, wait a minute, how can those savings be mostly on-peak when this resource is mostly off-peak? And the answer is it costs more to produce electricity during on-peak hours. And therefore, that's where most of the savings are going to occur. And that's what my analysis revealed. So building on that, I think you need to develop and try to refine your allocation methodology so that it reflects the times when the cost savings are greater. And so if an energy allocator were the right way to go, then what I would have found is that the energy cost savings would be occur in the same proportion as the energy itself, but that's not the case. What I found instead was the majority of the savings occurred during the on-peak hours, and therefore the on-peak hours should still get a premium allocation of the capital costs, and not an energy allocator. So it's a kind of a nuance, but I think it's important if we're going to go toward a time of use cost methodology. I think it's an important nuance to recognize.
Thank you for that clarification, Mr. Pollack. Nothing further, Madam Hearing Examiner.
Mr. Chairman, any further questions for Mr. Pollack?
No, that answer was very informative. Thank you. I learned something.
Very well. Mr. Pollack, thank you again, sir.
Thank you.
For appearing here today, and you are excused.
Appreciate your time and attention as always.
Thank you.
Bye-bye.
Anything further, Mr. McMillan?
Nothing further from OPL, Your Honor.
Very well. I believe then in the order, we are next going to the New Mexico Large Customer Group. Mr. Nelson, you have a witness.
I do, and he's indicated he's in the waiting room.
Okay. I don't see him waiting.
I'm sorry, who is the witness on?
Kevin Higgins?
Mr. Higgins.
Oh, okay, great. Okay.
Oh, I needed to scroll upward. There you are. Good afternoon, Mr. Higgins.
Good afternoon, Your Honor.
How are you?
I'm great, thanks. How are you?
Excellent. Thank you. You testified in our 2238 rate case previously,
Yes, I did.
and you are under oath in that proceeding?
Yes, I am.
And I just remind you that you're still under oath in this reopened proceeding. Okay?
Yes.
Very well. Go ahead, Mr. Nelson.
Thank you, Madam Hearing Examiner. Mr. Higgins, just as we get started here, can you please state and spell your name for the record?
My name is Kevin C. Higgins, Kevin, middle initial C, Higgins.
And Mr. Higgins, by whom are you employed and in what capacity?
I'm a principal with the consulting firm Energy Strategies.
And on whose behalf are you testifying in this proceeding?
I am testifying on behalf of the large customer group.
Mr. Higgins, did you cause to be prepared and filed what's been identified as NMLCG Reopened Exhibit 1, which I will describe to you as was entitled The Supplemental Stipulation Testimony of Kevin C. Higgins?
Yes, I did.
Okay, and just so we have ourselves oriented, do you have a copy of that in front of you today?
I do.
Okay. And was that testimony prepared by you or under your direction and supervision?
Yes, it was.
And are the answers contained in that testimony true and correct to the best of your knowledge?
Yes.
And if I were to ask you those questions today, would your answers be the same?
Yes, they would.
Madam Hearing Examiner, I would move the admission of NMLCG reopened Exhibit 1.
Mr. Higgins, did you have any corrections, additions, or deletions to your testimony?
No, I do not.
Very well. Is there any objection to what's been identified as NMLCG reopen exhibit number 1, Mr. Higgins pre-filed supplemental testimony that was filed on the 12th of November? Hearing no objection, NMLCG reopen exhibit number 1 is admitted. Mr. Nelson, anything further?
Yes, if I might, I have just a couple of questions I'd like to ask Mr. Higgins in response to some of the issues that have come up today. Mr. Higgins, have you been able to monitor the proceedings today so far?
Yes, I have.
Okay. I wonder if one of the issues that has come up and that has been discussed are the impacts to large customers and small customers from falling fuel costs because of the introduction of the Hale and Sagamore wind farms, and then the corresponding impacts on those same customers from rising costs potentially for fossil fuel resources. And do you have anything that you would like to add for the Commission's benefit on sort of how rising costs associated with changes in fuel prices for the fossil fuel resources might impact customers differently?
Certainly. The Exhibit A to the stipulation shows the benefits to customers from the introduction into rates of the Sagamore wind facility. But it looks at those benefits from the Sagamore wind facility in isolation. That is, because the Sagamore project produces production tax credits, and it also avoids the use of fuel. In isolation, it produces savings to customers. And as SPS pointed out today in Mr. Hudson's testimony, that with the recent increase in fuel prices, that the benefits from Sagamore are even greater. And I agree with that. And in presenting the allocation of results from that, which Judge Hurst has put up on the screen right now, it was, well, this is the original that we're looking at right now, but the original Exhibit A. But then in the updated version of the results, one can see, for example, that the net decrease in fuel costs to the large general service transmission class is greater than for other classes that do not use as much fuel in proportion to their overall costs. Now, what I will point out is that when fuel costs go up, the FPP-CAC charges increase. And that is not depicted here. This is simply showing the benefits from the reduction, from the benefits from the Sagamore facility due to the avoided fuel costs, which are now have gone up and which are producing greater benefits for Sagamore. But what is not shown is the fact that fuel costs themselves are increasing through the FPP-CAC. And those very customer classes, such as the large general service transmission and the primary general service classes, those very classes that benefit from the savings from Sagamore are simultaneously experiencing a higher percentage increase in their fuel costs as a result of the higher fuel charges through the FPP-CAC, which is not depicted here. So while on the one hand, if you look at the savings incurred from Sagamore in isolation, you might see this benefit that is relatively greater as a proportion of the bill for the high load factor customers. But what you're not seeing is that that very same fuel cost increase is hitting them harder than all the other customers as a percentage of their total bill, precisely because they use fuel in greater proportion of their bill. They pay fuel charges that as a greater proportion of their total bill than the other classes as well. So there's two sides to that story. We're showing one side here, but there's another side taking place through the FPPCAC.
Thank you, Mr. Higgins. Another topic that has come up today in questions from Chairman Fishman has been a question about whether the commission should be concerned about the fact that the stipulation does not specify sort of every item on a sort of a line item basis, and that parts of the stipulation are within what has been called a black box. Can you offer from your experience any thoughts on whether and the extent to which that should be a concern for the commission, or whether and the extent to which you feel like the stipulation is reasonable, notwithstanding the fact that not every item is enumerated?
I believe that the stipulation is reasonable, and that the fact that there are unspecified adjustments is not a problem, or should not be a problem. I addressed this in my original stipulation testimony on pages 7 and 8, where I walked through where SPS started in terms of its original ask in the case, which was around an $87 million base rate increase, and where the case wound up, which was in the ballpark of about $62 million. And I pointed out that where the stipulation wound up in terms of revenue requirement was very close to what the New Mexico large customer group had recommended in our own case. Even though the route to get to that final number included unspecified adjustments, the final impact, the final result on customers as a whole was very close to what we felt was just and reasonable. And it was a compromise. It was still a little bit more than we had recommended. But through the give and take and the willingness of parties to agree on some specified adjustments, but also to allow some latitude for unspecified adjustments, but still get to a reasonable revenue requirement, I think provides a benefit that's in the public interest, because it helps resolve the going forward revenue requirement through an uncontested agreement.
Mr. Higgins, also in discussions from Chairman Fishman, there's been some discussion with the previous witnesses about how the stipulation revenue allocation comports with the various cost of service studies that were submitted in the case, and sort of how the commission should weigh the value of those cost of service studies. And that is a part of your supplemental stipulation testimony. And so I just wanted to ask you a couple of questions about that. First, from your experience, can you talk about what value the cost studies that have been presented to the commission have in the context of this case, and what weight you believe the commission should place on those studies?
Well, the cost of service studies provide valuable information. I think they provide guidance to this commission. And even though there are disagreements about some aspects of the cost of service studies, what they have indicated is that for a number of classes, a similar outcome is obtained. And so because there are quite a large number of commonalities among the cost of service studies with respect to the recovery in certain classes, that allows for parties to reach agreement on a fair way to allocate the revenue responsibility even if there are disagreements about specific details of the cost of service studies, there are still a lot of inferences that can be made about what a reasonable outcome would be. And then, of course, on top of that, the parties agreed to rate mitigation over and above what the cost of service studies indicated would be cost-based rates.
And then
Cost-based rates?
Yes, sir, cost-based rates.
Thank you.
And then in particular, Mr. Higgins, could I focus your attention on the residential rate class? And can you speak to how the outcome in the stipulation compares to the cost of service based outcomes as presented in the different cost of service studies that were submitted to the commission in this case?
Yes, the cost of service study that allocated the fewest costs to the residential class was the cost of service study that SPS performed. And according to SPS's cost of service study, the residential class, if their rates were set at cost, would warrant an increase that was 30% above the system average increase. That was the most favorable cost of service study for the residential class. And so when Mr. Hudson said earlier today that the residential class is heavily subsidized, he was exactly correct. Even under the most favorable study, they would warrant an increase 30% higher than the average increase. Other studies, indicated that it should be as high as 192% of the system average instead of 130% of the system average. And in the stipulation, what the residential class received was 7.5% above the system average, which translates into 1.45 percentage points. So whereas the system average increase was, in the neighborhood of 19% and change, residential received 1.45 percentage points above that, or 7.5% above the average. And so if you look at it in the context of the cost of service studies, it was an outcome that was far smaller in terms of impact than the most favorable cost of service study indicated.
And then finally, Mr. Higgins, relative to that most favorable cost of service study, which was provided by SPS, how does that study allocate the fixed costs of the Hale and Sagamore wind farms amongst and between the customer classes?
That study allocates those costs on an energy allocation basis.
Thank you, Mr. Higgins. Hearing Examiner Hurst, those are all of the questions I have on direct, and Mr. Higgins is available for questions from the commission and yourself, and of course the parties as well.
Thank you, Mr. Nelson. Chairman Fishman, you have questions for Mr. Higgins.
Yes. And actually following up on Mr. Nelson's last question first, on pages, what pages? 12, 13, and 14 of your testimony, you state with certainty that you feel residential customers are saving money on Sagamore with the proposed rate design. Do you still feel comfortable with that statement?
Absolutely, Mr. Chairman.
Okay. And that's based on looking at the SPS cost study, cost of service study, and kind of extrapolating how it fits into the settlement. I don't know if I stated that very accurately, but correct me if I did not.
Well, it's close. I'll clarify just to be precise. what I looked at was using SPS's cost of service method and using the stipulation revenue requirement for the Sagamore plant. I allocated residential share of the Sagamore costs of the Sagamore revenue requirement using SPS's method, and compared that to the fuel savings from Exhibit A, which, as we now know, are even greater now than they were at the time of the stipulation. And I concluded that the residential customers are paying no more than what SPS would have allocated to them, because the overall stipulation capped the impact on the residential class at 107.5% of the system average, whereas the SPS study, which allocated Sagamore on an energy basis, resulted in a rate that would be a revenue requirement that would be 130% of the system average if residential were priced at cost. So clearly the stipulation mitigates the residential impact to a larger degree than the SPS cost of service study did.
Okay, so if that's correct, I fail to understand why we can't, why there's any obstacle to coming up with a rate design that's explicitly built around that model. You could come up with the exact same rate design that we've got now and base it on a model that allocates costs by energy, just by whatever particular adjustment scheme you put into place. Is that a correct statement?
I respectfully disagree with that statement.
Okay.
The parties agreed to a rate impact on residential customers that is even more beneficial for them than the SPS energy allocation produced. But that is the issue of gradualism. It's the issue of continuing the subsidy for residential class, for the residential class. And it's in recognition of the fact that, well, one wants to move gradually in terms of rate impacts. That is still separate from the fact that the parties do not all agree on the proper way to allocate the Hale and Sagamore plants. And so we haven't reached resolution there. And in fact, even if one were to move down the road of an energy allocator, as Mr. Pollack pointed out, there are changes that would have to be made, in fairness, to the way the fossil plant is allocated, what many of us believe. And so it's not really just a simple matter of changing the allocation to an energy allocator and being done with it. There are a lot of other issues in the mix. But what we can agree on is that for purposes of this case, not impacting residential any more than 107.5% of the system average.
Okay. So in listening to your answer, I'm hearing that, this is what I'm hearing, is that the parties can't agree, but that doesn't mean that it couldn't be done in terms of using the energy allocator as a base before you make all the other adjustments to get to the final number, as a base for handling Hale and Sagamore. So if the commission were to say, okay, we want to do that as the base, and actually we're going to come up with the exact same numbers you came up with, but we're going to do it another way just to show that, hey, energy allocation is the way to do this. That could be done as a way of calculating it. Whether the parties agree or not, it could be done. Am I interpreting that correctly?
Chairman Fishman, I mean, the commission has a wide range of prerogatives, I believe. I'm not an attorney. And so, the commission has to, at the end of the day, decide on this case. What I would respectfully ask you to consider is that the parties negotiated in good faith on an outcome that greatly protected the interests of the residential class and achieved an outcome that was it allocated no more revenue requirement responsibility to that class than they would have gotten under an energy allocator. But in light of all the other unresolved issues about proper cost allocation, I would ask you respectfully to allow that to remain an open issue to be addressed at a later time.
Okay. And by the way, that was a hypothetical. I don't think that's something we would do. That was a hypothetical. So I'm going to go back to the black box issue, which Mr. Nelson touched on with you. And so I'm looking at a number of issues that are used to build a rate. And that might be issues that the commission wants to get clarity on because it wants to set an example or create a way of thinking about certain problems and issues as we go forward. And so we just talked about one, the energy allocation and capacity. It's black box, so people can't agree, and we've kind of gotten a little fuzzy around it. Okay, I get it. With the previous witness, we talked about, now that we're 45% renewables for the energy generation part of rate making, perhaps the idea of load factor is becoming outdated as a way of allocating that particular piece of the cost picture. Another area could be cost of capital and debt ratio. Is that when you put all that stuff into one amorphous package, doesn't that take away the commission's ability to create a record about where we should be headed on those issues? And well, I'll leave it at that.
Chairman Fishman, I hear what you're saying, and I respect your perspective on that. I think that on the other hand, if you look at the stipulation in its entirety and look at the full record of the case, and you look at where the revenue requirement landed, and I think you can also appreciate that all the parties, the company and as well as the staff and interveners and attorney general were able to take the many factors that were put in evidence in the case and distill it into a package that at the end of the day has a reasonable outcome. And so I can certainly understand from your perspective that you would probably like to see certain other details specified. The difficulty is that had we been forced to do that, we may not have been able to reach an agreement. And so one has to weigh the benefit of having, in essence, an uncontested agreement on revenue requirement, not an easy feat, And but recognize that while we were able to call out some details, that parties could live with it if a certain portion of it was unspecified. And recognizing, I hear what you're saying about it potentially being some frustration for the commission, but I think that overall, you of course want to look at the public interest generally and see that there's a lot of merit in the parties being able to reach an agreement on the revenue requirement itself.
So, and I understand that argument, and nobody wants to have to litigate everything. And settlements can be good. And of course, the issue for me isn't so much settlement, it's that it's black box. And that's the issue I'm exploring. And I think you understand, I think you pretty clearly understand the perspective that I have is that, gee, when we black box it, there's a way we lose the opportunity to create the kind of record on these various issues that allows the commission to, if I might, it could be a precedent, it could be, call it what you may, create a record that shows how these issues might be best addressed. And whenever we say yes to a stipulation, we give away some of that power. And when it's a black box stipulation, it gets even more muddy. What I just said there, did that change your understanding of my position, or is that pretty much consistent with that?
No, I appreciate your position, and I would just maybe add that you haven't given away any of your power. It's still there. You still have the ability. It's held in reserve, if you will.
Sure.
And there will be future cases. Some of them will go to litigation, at which point the commission can issue specific directives on every single item in the case.
I think that's it. I thank you very much for taking the time to testify, and your answers were very, very clear. I appreciate it.
Thank you very much. I appreciate the opportunity.
Again, parties that indicated they did not have questions for each other's witnesses. However, this is your last opportunity to change your mind. Hearing nothing, any redirect, Mr. Nelson.
Yes, thank you, Hearing Examiner Hurst. Mr. Higgins, relative to the last line of questions that you had with Chairman Fishman, I just wanted to explore a couple of ideas. First of all, do you see benefits when the seller of a product, in this case, the utility, and the buyers of a product, in this case, the customers, either as individually represented or represented collectively by the public agencies in the case, agree on what the price should be for that product? Is there a benefit there? And if so, what do you see as that benefit?
Well, certainly there's a benefit. Prices in for monopoly utility services are administratively set, as we all know, and this settlement represents, in essence, the agreement of the buyers and sellers as to what the fair price ought to be.
One of the other issues that I wanted to raise in this context, and I don't know, but Mr. Higgins, by any chance, do you have a copy of the stipulation that was reached in this case available to you?
Yes, I do.
If I could just ask you to pull that up.
I have it. I have a hard copy of it in front of me.
Okay. And just by way of starting, I want to just explore sort of what it means that there is a quote unquote black box, and in particular want to make sure that the record is clear on what the degree, if you would, of black boxiness there is in this stipulation. And I'll call your attention first to page 3 and Roman numeral 1, agreement as to base rate increase. And let me know if you have that in front of you.
I have it in front of me right now.
Okay. So as a starting point, would I be correct that the stipulation starts from the $87,742,544 revenue requirement that was identified in excruciating detail in SPS's application in this case? That's essentially the starting point for how the parties derived the ultimate agreed revenue requirement.
Yes, and I think the number you read might have been a little bit different. I think it was $87,782,544.
Correct. I apologize if I misread that. Okay, and then would you agree with me that from that starting point, the stipulation actually calls out in the paragraphs below a number of specific enumerated adjustments to that revenue requirement, which includes, for example, a proposed rate of return on equity for purposes of determining the Hale and Sagamore customer protection calculation from the CCN, capital structure, specific depreciation rates, the treatment of rate case expenses, the treatment of amortized attachment Z2 expenses, generation overhaul adjustments, that those are all specifically called out, then modifying to some differing degrees the starting point from SPS's filing. Is that true?
Yes, that is correct.
Okay. And then what is then the quote unquote black box is, am I correct, specified and discussed only in paragraph 8 of the stipulation on the top of page 4, which is an unspecified adjustment in the amount of some 14.9 million. And as the stipulation explains, which includes an adjustment for a 9.35 ROE. Do you see that, sir?
Yes.
Okay. And so I guess relative to that, do you think it is fair to describe the way that this calculated? Is it in fact a complete black box? And if not, what would you encourage the commission? How would you encourage the commission to view this in light of what is spelled out here in terms of how the revenue requirement was calculated for purposes of the stipulation?
I would not characterize the entire settlement as a black box. It has, as I even pointed out in my discussion with Chairman Fishman, it has specific items that are enumerated in the stipulation. And it does have one, material, unspecified adjustment in an amount specified in dollars, but not specifying the entirety of what the details behind that adjustment. And that is the extent to which one might say, well, it has an element of a black box to it because it has this unspecified adjustment as a piece of the overall stipulation.
And Mr. Higgins, I don't know if you remember this figure, but would it be possible to derive sort of the value of that unspecified adjustment, for example, if the commission so desired, purely in terms of a change to the rate of return on equity? In other words, keeping everything else as specified in the stipulation, starting with the company's filing, making the specified enumerated adjustments, and then solving for the number, if you would, that's in the stipulation, adjusting only the rate of return on equity. Is that something the commission could do if they wanted to get comfortable with the end result?
That could be done mathematically, yes.
Okay. Do you have a, do you, I believe you may have done this in the past, but do you have any recollection of what that calculation would be in terms of if the unspecified adjustment were purely viewed as an ROE adjustment, what that would translate to?
You know, I don't recall it off the top of my head, Mr. Nelson.
All right, fair enough. And then the last thing I will ask on this point, and understanding that you are here only for the large customer groups and obviously are not speaking for customers in New Mexico generally, but relative to, you know, an industrial customer that is buying power from SPS and understanding that they care about these issues sufficient to at least, you know, hire us to show up and present these arguments to the commission. At the end of the day, when they look at what their bills are, how important is it to them exactly how the commission derived whatever is the ultimate rate?
My experience is that the customers are most interested in the bottom line. What is the ultimate rate that I am going to have to pay, and how does it change compared to what I've been paying?
Thank you, Mr. Higgins, and thank you, Hearing Examiner Hurst. I have no further questions of the witness.
Thank you, Mr. Nelson. Mr. Chairman, anything further for Mr. Higgins?
So first of all, Mr. Higgins, the answer is yes. Mr. Higgins, is it possible for you to do the calculation that Mr. Nelson just described and submit that for the record?
Yes, that can be provided.
If I could just ask for clarification, Mr. Nelson, are you referring to the calculation that was done several times to the original Exhibit A during the our first rate case hearing?
Madam Hearing Examiner, I'm pretty sure, and I apologize, I don't have the site right in front of me, but I am pretty sure that in the course of the original hearing, this question and this exact point was raised, but that's why I was sort of wanting to re-raise it. But I believe that it is already in the record exactly what that calculation would be if you essentially, as I described, took the enumerated elements of the stipulation and then backfilled for what the ROE would be to arrive at the stipulated outcome. I believe that was discussed. I will say, I'll go, you know, my memory is that that is in the record. I'm happy though to undertake to identify that if that would be useful and find that in the transcript if that's helpful.
I think we did it like 5 times. If I remember correctly.
I think that may be right. And
depending with several witnesses, I think it was done. But Mr. Nelson, I think we'll take you up on your offer, and as a bench request, if you would identify in the original hearing record where the calculation is either probably better through your witness, but if you identify the other instances where I remember that other witnesses, I believe at the SPS witness had done it, and maybe some of the other interveners. So consider that a bench request, Mr. Nelson.
I will, and I will. We have a couple more witnesses, and so possibly I'll be able to report back on that contemporaneously here later today.
Very well. Mr. Chairman, anything further for Mr. Higgins?
And just real quickly, I don't want to get too deep into this. When we're saying I'm trying to think of a good analogy, but I give up. I think what we want to do here, I acknowledge the idea that there's some information that is specified here. But I look at that 15 million and I could basically say, well, what does that 15 million mean? And that adjustment. And I could attach it to any one of those items. And that really blurs the lines in my mind. Is that could you please refute that, that assertion?
Chairman Fishman, I think that it's an indication that there are issues that parties have raised in revenue requirement adjustments that they believe are reasonable, but which not all parties can come to agreement on.
Yep.
In terms of conceding the specifics about a point, conceding whether a certain cost should be disallowed or not. And so requiring an enumeration of those items can be an impediment to reaching a reasonable overall result.
Mm-hmm.
And so I think what the parties wisely did in this case was agree not to have to specifically enumerate every adjustment because they would not agree and concede certain points, but yet agree to a total impact that everyone could live with.
Would you agree that when the commission has the opportunity to set certain standards and decision parameters around issues like energy allocation, cost of service methodology, ROE, that helps the commission make better decisions going forward?
I don't know, honestly, that it necessarily helps the commission make better decisions going forward. I do believe that it does, for the purposes of that case, provide an indication of the commission's preferences, and does provide information to the parties going forward in that regard. Although we know that from case to case, a commission doesn't necessarily bind itself either.
Mm-hmm.
So I'll leave it at
that. Would you agree that when those issues are not clearly resolved, that potentially, when issues come up at a later date and those issues are not clearly resolved, that it creates additional burdens to figure out how to resolve an issue because we haven't created a clear record of what our decision criteria are?
Mr. Chairman, that's obviously an abstract question. I appreciate where you're coming from with it, but my experience is that these types of disagreements on issues tend to be very fact-driven. And so whether it's problematic would really depend on the facts surrounding a particular issue and whether there is an issue in between rate cases that somehow needs to be resolved on the basis of prior commission decisions. But most of these are items that come up in a general rate case. And so to the extent that they come up again, and to the extent that the parties are not able to provide the commission with a stipulation and it goes to litigation, the commission will have that very opportunity to referee every single one of these issues in contention. But I don't think most of these things are not going to be a problem in between rate cases.
Okay. That's all I have. Thank you again.
Thank you very much.
Very well. There being no further questions. Mr. Higgins, thank you very much, sir. You are excused. And Mr. Nelson, I will await either post-hearing or later in this hearing to hear with regard to bench request 2. Very well. I believe we are on then to our next witness. And I believe Mr. Elliott, the next witness is the Attorney General's witness.
I believe Ms. Crane is joining us now.
Yes. Good
Yes.
afternoon.
Good afternoon, Ms. Crane. How are you?
I'm fine. How are you, Madam Hearing Examiner?
I'm doing okay. You testified in the beginning hearing in this case, correct?
Yes, I did.
And you were under oath during that testimony?
Yes, I was.
And I remind you that you are under oath again.
Very good.
Just a reminder, that's continuing. And if you would like to go ahead, Mr. Elliott.
Thank you.
Madam Hearing Examiner, real quickly, just to give upfront warning, I am not going to have any questions for Mr. Barron. So.
Okay.
Just so he's not waiting around.
Very well. We will, subject to no objection from the parties in stipulating Mr. Barron's testimony, we will go ahead and take care of that at the conclusion of your questions for Ms. Crane. Okay. Okay, go ahead, Mr. Elliott.
Good afternoon, Ms. Crane.
Good afternoon.
Ms. Crane, on November 12th, well, first off, Ms. Crane, do you have what's been submitted this morning as NMAG reopening 1?
I do.
Okay. And do you also have a copy of your supplemental testimony in support of the uncontested comprehensive stipulation and response to the 7th bench request that was filed on November 12th?
Well, I thought that was NMAG reopening Exhibit 1. Maybe I'm mistaken then.
We marked it. I just want to make sure that what we had circulated and filed is what we marked this morning as NMAG response 1.
Yes, I have it.
Okay, and are those the same documents?
Yes.
Okay, and are your answers today the same as they were on the 12th when you filed your testimony?
Yes, they are.
Okay, Madam Hearing Examiner, I pass the witness.
Ms. Crane, were the answers that you gave in your testimony true and correct to the best of your knowledge?
They were.
And if you were asked the same questions today, would your answers be the same?
They would.
And were the attachments to your exhibits to your testimony, were those prepared by you or under your direction and control?
They were.
Very well. I'm assuming, Mr. Elliott, do you want to offer NMAG reopen exhibit number 1 into evidence?
I do.
Very well. Any objection to what's been identified as NMAG reopen exhibit 1? Hearing no objection, NMAG reopen number 1 is admitted. Anything further, Mr. Elliott?
No.
Very well. Mr. Chairman, you have some questions for Ms. Crane.
Yes, I'll start with the kind of the most general one that I raised earlier with Mr. Hudson. And so much of the testimony is around at least how the cost of service and how the revenue requirements are divvied up are centers around cost of service. And the models that show that actual cost of service is not well reflected in how revenue requirements are divvied up between classes currently. And I want to ask the question, given that this has been the case for many years, is there any particular thing going on that creates urgency around this issue in this rate case?
Not that I'm aware of, no.
Okay.
I mean, I think the parties would generally, generally try and head towards cost of service, but I don't think that there is anything right now that is critical at this juncture.
Okay. What prior to now, has there been anything on the record that spoke to the particular challenges that certain customer groups are facing now in terms of affordability on their utility bill?
I don't recall any specific testimony to that effect, but the record in this case is vast, so it certainly is possible that it's in there. But I don't think that there's been I don't think has been an extensive discussion of the other cost pressures that some of the ratepayers are experiencing.
Okay. Were you listening in when I was examining Mr. Hudson on this issue?
I heard a little bit of Mr. Hudson's testimony, but I believe he was on the stand for a while and I did not hear all of it.
Okay. I was pointing out that certain classes of small customers are under pretty intense pressure, particularly the low income ones and small commercial enterprises, and had pointed out the big rise in delinquencies over the last year among those customer groups, pointed out that there's heavy core inflation, which actually is reflected in fuel costs right now, that tends to impact those folks most heavily. And then, of course, we've got the pandemic issues. Are those issues, in your mind, legitimate issues that we should be considering?
I did hear that testimony, and yes, there's certainly legitimate issues that we should be considering. And I think those are the types of issues that I think the commission should always consider. I mean, right now we are, I think, in extraordinary times with the pandemic and with what has happened to uncollectibles and those sorts of issues. But affordability is something that I think the commission has always taken into account in some degree when they're faced with the issue of cost allocation, and actually when they're faced with the issue of the overall revenue requirement as well.
And am I correct? And this is kind of really sort of an opinion, so let's take this question for what it is. Do you sense that larger industrial enterprises are facing these challenges to the same degree that small residential and commercial customers are?
Well, I haven't done any study specifically of that issue. However, in supporting its gradualization adjustment, SPS noted that one of the factors that it considered has been the rapid expansion in certain industries, certain large customer groups, oil and gas in particular. And so, based on that testimony, it might suggest that there are some classes that have been doing perhaps better than other classes. But I have not done an in-depth study of that issue.
Okay, thank you. And I'm going to explore for a second the issue of gradualism. Actually, you'd referred to gradualism adjustments and the adjustments that were made by Mr. Luth in SPS's original filing. And, I look at the testimony regarding gradualism from all other parties. And it seems there's a broad range of opinions about what constitutes gradualism. Is there any objective definition or history or anything that you can point to that defines what meets the criterion of gradualism and what doesn't?
No, I don't think there's any objective criteria. I think each witness has perhaps their own view as to what constitutes rate shock and therefore what should constitute gradualism, because obviously that's why we adopt gradualism adjustments in order to prevent rate shock. Usually, I mean, there are broader implications than just rate shock in any particular case, but I don't think there is an objective standard. And I think the ability of any rate class to absorb a rate increase, it changes over time. There are, when economic conditions are good, presumably there is a greater ability to absorb a rate increase than when conditions are poor. In addition, there's obviously quite a variety of people and ratepayers within any one rate class. So, obviously there are some residential customers that are doing just fine. And unfortunately, there's a lot of residential customers that are not doing so well. So it's very difficult to come up with a completely objective standard with regard to gradualism or rate shock.
Now, I was involved in one case, we recently had it before the commission, where there was a proposal for a 10% adjustment to the ROE. And that was an adjustment that was after 6 years since the prior rate case. And one of the arguments that came up, and won the day to a small degree, was that 10% change over 6 years violated the principles of gradualism. I know it's a really rough example, but perhaps you can make some comments about whether you think that was an appropriate use of that concept, if you will.
Okay, I just want to ask you a question for clarification. So that was a 10% increase in the return on equity being proposed. It wasn't that they were proposing a 10% ROE, but a 10% increase in their return on equity.
So going from, in this case, it was a decrease. So let's just use the example of going from 10% to 9.1%. Going down that much after 6 years since the prior rate case.
Well, capital costs are interesting because capital costs are changing all the time. And so, and they can vary greatly from period to period. And they are kind of slow to increase. The commissions generally are slow to increase ROEs, and they're also usually slow to decrease ROEs. So commissions generally lag with regard to with regard to their ability or their willingness to adopt a new return on equity. I would say overall, I would think that a 10% increase over that period of time does not constitute rate shock for an expense in the ordinary course of business. With regard to ROE specifically, there are so many other factors, external factors that impact that it's difficult to say specifically to that example.
So over 6 years, that's like 1.8% change per year.
Correct.
If you add it up, something like that.
Yeah.
So I posited a situation here earlier that given the past rate case, the current rate case, and grid mod, that if you added up what the company, what might happen here, what's proposed in this stipulation, and what was decided in the prior rate case, and what's been proposed in grid mod, that could amount to a 20% increase in small commercial and residential rates. And by the way, that's only in small commercial and residential, because there's an argument about whether grid mod applies to the larger customers. How would you view that in terms of being rate shock?
Well, it certainly is approaching rate shock if it's not there. And I did hear a testimony earlier today, I believe from one of the company witnesses, that you don't really have to worry about the grid mod. That's going to happen, that's going to take some time. And the implication, I believe, was that rate would not be implemented for some time. But it's my understanding that the company is actually requesting that rate, that rider, be implemented approximately January of 2022 in order to begin to collect the accelerated depreciation of the legacy meter. So in fact, that is another component that we do need to keep in mind. I think the other thing that's disturbing is, let's say it is a 20% increase. Unfortunately, it's not over 6 years, as your prior example was. It's over a much shorter period of time. And so I think that when you are looking at increases of that level, it definitely is something that the commission needs to take into account.
So over 3 to 4 years, let's say 3 years, that's close to 7% a year.
Right.
7%.
In a period of generally low inflation too, up until now. We have enjoyed a period of low inflation. And in addition, the company has indicated that they plan to file a base rate case towards the latter half of 2022 as well. So, you'll be facing another SPS rate case at some point. And I think you do need to be aware of that. And I mean, having said that too, we knew that Hale and Sagamore were going to be expensive. I mean, I filed testimony on that. It's about a 40% rate base increase. And, at the end of the day, to some extent, we needed to be prepared for at least the increases associated with Hale and Sagamore because we knew that they were coming.
Actually, I'm not nearly as worried about that because it seems to me we're already getting simultaneously, by the way. In fact, before we're getting the increase, we're getting the fuel cost savings because of regulatory lag. So it seems to me that applies maybe more to the other assets that we're talking about that are more capacity related than Hale and Sagamore, where the cost is coming right back to us. It's a cost saving plan, right, if you will. Okay. I'm done. That's all that I wanted to cover with you. Thank you very much.
Thank you.
As previously mentioned, parties had indicated they had no questions for each other's witnesses. Now would be the time if a party has changed their mind. Hearing no verbal response. Mr. Elliott, any redirect for your witness?
No, Madam Hearing Examiner.
Very well. Ms. Crane, we appreciate your time. Thank you very much. You're excused.
Thank you very much.
Anything further, Mr. Elliott, from the Attorney General's office?
No. No,
Thank you.
Madam Hearing Examiner, before we move on, this is Thor Nelson.
I'm sorry. Start again, Mr. Nelson. I didn't recognize your voice.
Sorry, my apologies, Mr. Lee. I keep doing that twice today. Before we move on, could I pause to respond to the chairman and yours question
Sure.
regarding the previous record?
Go ahead.
Okay. So during Ms. Crane's testimony, I had a chance to dig into this a little bit. And here is what I can report. So in SPS's supplement to the 5th bench request order, bench request number D, SPS quantified that a change to the revenue requirement associated with a 10 basis point change to ROE was $1,168,030. Building off of that bench request response, I had a discussion with the NMLCG witness, Mr. David Garrett, where we discussed the implications of this a fair bit. You can find that discussion at the transcript for July 29th, 2021, from pages 1039 to 1049. And if I'm permitted to just summarize that for yourself and the chairman, although happy, of course, to call a witness if that would be helpful. What Mr. Garrett explained there is that if you look
Wait a minute. I mean, I think all we need is the reference, Mr. Nelson.
Okay.
I think I know attorneys want to testify, but let's just say that, you've located where that is and that that's what we ask you to do. Okay. Any further information to report?
No further information, but again, if the commission would like us to have a witness to explain that or answer any questions, we're happy to accommodate that.
Mr. Chair.
Yeah, Madam Hearing Examiner, I just wanted to say, sometimes commissioners want to testify too. I have to own up. Thank you.
Very well. And the reference is sufficient to
So
answer.
I thought I drifted for a moment. I apologize. We have pages 1039 to 1049 from July 29th testimony.
Yes, sir.
Did I miss something before that?
Just that it is question and answer between Mr. Nelson and his witness, Mr. Garrett.
Okay, great.
Okay.
Thank you.
Thank you. Thank you, Mr. Nelson. Okay.
You're welcome.
Madam Hearing Examiner,
Ms. Drake.
I'm sorry to interrupt. This is Joan Drake for LES. I just wanted to bring to your attention that rang a bell with me, and another site on that that might confirm what others have noted on that same point is Commission Exhibit 22, which is FEA and LES's joint response to the 5th bench request order. And if you look at the response to request number 5D, and that would be on page 17 of Commission Exhibit 2, I believe LES and FEA's witness, Mr. Gorman, came to close to the same conclusion. I think his response was about 1.3 million, but that's another citation that you could look at on that question.
Thank you, Ms. Drake.
Sure.
Did you get that, Mr. Chair?
I got it. Thank you. Yes.
Very well. Anybody else find a reference? I still think that I remember getting that Exhibit A up there a lot, and several witnesses, either maybe it was one witness being asked multiple times. I can't specify at this point, but I remember us looking at Exhibit A and the questions posed, and so I think there's probably some more in the transcript. But thanks to the parties for those references. Okay, I believe we have one witness remaining, and Mr. Moffett, the chairman has indicated that he does not have questions for your witness, Mr. Barron. So can you tell me whether or not Mr. Barron had any additions, corrections, or deletions to the testimony that he filed on November 12th?
Thank you, Madam Hearing Examiner. I can tell you, this is Mike Moffett for COG. He does not have any modifications or changes or additions.
Very well. And we're referring to COG reopen exhibit number 1, which was the testimony of Stephen J. Barron. Is correct, sir?
That is correct.
Very well. As there are no corrections, additions, or deletions, the chair has indicated he has no questions for Mr. Barron. Is there any other party that's going to have questions for Mr. Barron? Hearing none, is there any objection to what has been identified as COG reopen exhibit number 1, the testimony of Stephen J. Barron in response to the commissioner's order and 7th bench request? Hearing no objection, COG reopen exhibit number 1 as identified is admitted. Anything further from COG, Mr. Moffett?
No. Can Mr. Barron be excused?
He is excused. I'm sorry, I thought I excused him before we did this, but yes, he is excused.
Thank you very much,
Mr. Barron. I see that you're in the waiting room. Appreciate you being here, and you're excused. Very well. Anything further now, Mr. Moffett?
Nothing further. Thank you, Your Honor.
Thank you. So it looks like to me that Mr. Du Bois,
Yes, Your Honor.
hi. Did you find out that percentage of increase in 19-00170 for the residential and small commercial?
I think we have a written response almost ready, Your Honor.
Oh, okay. You're going to file a written response on that? Okay.
Yes, Your Honor.
Very well. And then, so that was bench request 2. So the only outstanding bench request that I know of then is the opportunity, and it's a permissive opportunity. You don't have to, but if you want to opine on, I believe it was black box stipulations, and whether there was any legal decision concerning that type of stipulation. Is that correct, Mr. Chair? Is that your interest?
Yeah, it was whether there was any court opinion that spoke specifically to black box as opposed to any stipulation.
Okay. All right. That is bench request number 1 as as clarified by the chairman. And what do you think, Mr. Chair, by close of business on Friday?
Yeah, that's fine.
Very well. Like to see any post-hearing filing, then my computer is covering that up. So that would be on by the 19th. Okay, well, let me ask a procedural question. I believe we have completed the evidentiary portion of our reopening hearing and just cautiously ask whether or not parties would like me to set a date to file, I don't know, some type of legal briefing with regard to the issues in this reopened hearing.
Your Honor, Will DuBois for SPS. What I might suggest would be that the parties have the opportunity to prepare perhaps an addendum to the proposed certification of stipulation that was already presented to add to it in light of this further proceeding.
And I know we have Thanksgiving next week. You think it can be done before Thanksgiving?
If the question is, do I think it can? I would say
Let me rephrase that. Let me, in the interest of eventually getting you a certification filed with the commission. You know, SPS has gone to some great lengths to talk about the importance of trying to get you a decision, and for this is one thing I do not speak to for the chairman or the commission on. I'm only speaking selfishly for myself, and my role in here is that, you know, I would like to get you a certification, is, you know, as quickly as I can in my lifetime. So
I'll just say yes, Your Honor. I'll just go with yes.
Yes. So you're going to go with yes, you can get this on or before by close of business on the 24th?
Yes, Your Honor.
Very well. That's the answer I wanted to hear. Thank you, Mr. DuBois. All right. Do we have anything else procedural that we need to deal with? I believe Mr. Lee, that you have all of the exhibits except do we need to send you a marked up copy of Mr. Pollock's amended testimony that changes that one number on page 3?
You know, I thought somebody resubmitted that already, but if I don't have it, I absolutely need it. That statement was off the record.
Okay. Mr. McMillan, my understanding is that Mr. Pollock corrected his testimony on line 22 of page 3 and changed the number 186 to 167.
That's correct.
And have you emailed that to me?
I will email it to you shortly. I'm getting the .doc version right now, and we'll get it to you in the next few minutes.
Okay. All right. I need to send that to Mr. Lee.
Is that Mr. McMillan?
Yes. Mhm.
Yes.
Thank you.
And I don't believe that any other witness had a correction on their testimony. Parties can correct me if I'm not accurate. Okay. All right. So that will take care of our exhibits. That takes care of any post-hearing writing. We finished with our evidentiary matters. Does anyone have any other procedural matter that we need to deal with? Mr. Chairman, do you have anything that you would like to say or any issue you think we need to deal with?
Just thank you to everybody. Thank you for the testimony, and thank you again, David and Hearing Examiner Hurst. Terrific job just moving through this hearing. I appreciate all your patience. And, welcome. Mr. Du Bois spoke about potential amendment to the stipulation. And certainly, if as a result of this hearing, I certainly welcome any final adjustments that you all might want to make.
Just for clarification purpose, Mr. Chairman.
Sure.
What Mr. at the end of August, the parties filed a proposed certification of the case.
Okay.
Sort of like a proposed recommended decision.
Okay.
Okay. So all he's saying is he'd like the opportunity to add on to the proposed RD.
Yeah.
Okay. I did not hear him say that they're going to amend the stipulation.
Okay. I thank you.
Okay.
Poor choice of words. I'm
Yeah,
sitting here with a bunch of lawyers, parsing words. And the only way it could be worse if Bill Clinton was sitting in with us as well. I'm overwhelmed.
Just wanted to clarify for that. I didn't want you waiting for
Thank you.
for your holiday present, and it wasn't going to be there. And,
Appreciate it.
Okay, very well. Thank you, Mr. Chairman. I'd also like to thank the parties for being able to get together in such an expeditious manner, and appreciate that you all could make those accommodations. If there's nothing further, this hearing is recessed. And Mr. Lee, I will get you that exhibit as soon as I have it.
Thank you.
Thank you. We're recessed. Happy holidays and a really good new year to us all.
Thank you. Same to you.
Thank you very much.